Bar. And Elizabeth, could you please call roll?
Sure. Uh, Judge Holly Fougier,
Here.
Judge Brenda Harbin Forte, Connie Broussard, Adayenka Glover, Melissa Hung, okay. Genevieve Jones Wright, Esther Kim, Catalina Lozano, Kwazan Malouf, Emily Quinlan, Gary Roberts, Donna Sheely, Mark Shem, Barry Weissman, okay. And then we have board liaisons, Hyland Chen, okay. Debbie Manning,
Here.
and are there others on the conference line that would wish to identify themselves? Okay.
All right.
And
So I understand we have a quorum?
Yes, we have a quorum.
All right. Thank you, Elizabeth.
Would you like staff to introduce themselves?
Yes, please.
Hi, I'm Carolina Amarant-Serrero. Good morning, I'm Carolina Amarant-Serrero. I'm an analyst with the Office of Research and Institutional Accountability.
Good morning, this is Helen Hong. I'm the Director of the Office of Access and Inclusion.
Elizabeth Hom with the Office of Access and Inclusion.
Good morning, I'm Brady Dewar with the Office of General Counsel.
Leah Wilson, the Executive Director.
Donna Hershkowitz, Chief of Program.
All right. Good morning, everyone. All right. So we're going to do the call for public comment. Is there anyone, any member of the public who would like to speak to any item on the agenda?
Good morning, this is Helen Hong. I'm the Director of the Office
Hearing
of Access
nothing,
and Inclusion.
we'll proceed with the agenda. All right, we first have our consent calendar, and item A is the approval of minute summary and action items from the March 1, 2019. And can I get a motion to approve the meeting summary? All right, we have a motion from Mark and a second from Barry. Elizabeth, can you do the roll call for the vote?
Judge Holly Fougier? Yes. Judge Brenda Harbin Forte? Yes. Connie Broussard? Adayenka Glover? Yes. Melissa Hung? Genevieve Jones Wright? Esther Kim? Catalina Lozano? Yes. Kwazan Malouf? Emily Quinlan? Gary Roberts? Donna Sheely? Mark Shem? Yes. Barry Weissman? Yes. Okay.
All right, motion passes. Thank you. All right, so our next section is on State Bar reports. And we're going to have a report on recent developments of the Office of Access and Inclusion from Helen Hong. It's right behind me. Take it away, Helen.
Good morning, Commissioners. It's nice to have our council members. It's nice to see you all face to face. I know my last meeting was through video conference when we were in LA and in San Francisco. I'm really hoping that everyone gets cookies today so that we avoid a revolt as in last time. I am pleased to give you some updates that we've been working on since our last meeting and in the same area. One of the areas that you have seen in your email attachment was the report to the legislature on our diversity activities. Hopefully you had a chance to review those. We do have hard copies here. And it really talks about some of the progress that we've made in the history. Really, that was the foundational work through COAF. What was happening and what is it that the State Bar Board has identified in its strategic objectives that really has shaped and informed with COAF for the strategic goals and objectives that are is in the work plan today. Since that meeting, the Board of Trustees adopted and approved the work plan that I just passed out. So you'll see that. And one of the areas that I wanted to also share and also ask the chair to discuss on was the hearing on diversity and inclusion by the Assembly Judiciary Committee, where we had Halen Chen, one of our board members, present, as well as Judge Fujie. And so I'm pleased to share that in the Assembly Judiciary staff report, their recommendations on areas to improve the legal profession includes many of the items that are in COAF's work plan. Sorry. Okay. The other two areas that I would want to update, there were some, we had two major COAF activities, one including presentations by both judges at the Law School Assembly on law school retention programs and identifying law school activities to support retention and graduation for students from diverse backgrounds. Elizabeth will be presenting a little bit more on that data, but the two areas that there were two follow-up questions on the BAR Strategies and Stories program, formerly known as Productive Mindset, which came out of the Council on Access and Fairness to address increasing BAR passage rates for students from diverse backgrounds. Just in summary, this is an intervention that supports really the psychological stressors, particularly from students from diverse backgrounds, on taking the bar exam. The control group showed that it increased the bar passage rate by 7%. The group that actually had the intervention itself showed it up to 18% bar passage rate.
Higher bar passage or just plain bar passage rate? 18%. Yeah, that's what I figured. Yeah.
And so there were two follow-up questions from COAF members.
Yes.
Okay. One is, what did the control group receive? And it was basically about bar preparation, study strategies, how to, what you would normally find on a Googling, like, you know, how do you prepare? What are some of the basic study strategies? That was the only thing that they received. The control group was a 45-minute session on addressing the psychological stressors, on remembering why they took the bar, understanding that everyone is under the same stress, but then also when they were under a lot of stress, handling remembering why they were doing that. There's more information that was in the diversity report itself, but someone asked what was the treatment, and it is that just one 45-minute session. I think Judge Fujie, you had asked that.
It was asked by a number of other members who were there.
And so I wanted to follow up on those two questions. The last thing that I wanted to give you an update on is, as part of the bar cut discussion, the Supreme Court has asked for 3 additional reports from the State Bar, including the California attorney practice analysis, understanding what skills are necessary and what are they actually practicing, to understand how best the bar exam tests on those areas. It's known as the CAPA study. That is actually going to be happening this year, and in order to promote more participation by attorneys, we are asking communications, and the Office of Research and Institutional Accountability is asking for attorneys to do interviews about what how their practice has changed over the years since they took the bar exam, and how they're practicing today. There'll be 2 video shoots, one in San Francisco and one in Los Angeles, on the 17th and the 12th. If you know individuals that you would like to suggest to be on camera to talk about this, it'll be shared on social media and on the bar itself. I would encourage you, if you have any ideas, to please email me, and I'm happy to share that information.
it's not going to work.
Hi, it's Teresa Ruano from Communications. A quick correction. Shoots are the 17th and the 21st. 21st in LA, 17th in San Francisco.
Thank you, Teresa. And so if you have suggestions for attorneys to be in the interview, of course, we want to have diverse backgrounds, practices, as well as stories. I would really highly encourage you to let me know, and I will share that information so that we can have those interviews shared amongst the licensee population of California. Yes.
Your turn.
Hi, it's Catalina Lozano. It's not working.
It's not working.
If I ask an attorney to participate, the attorney will want to know how long shoot is or how long to set aside for the whole thing.
So I'll have Teresa respond.
What we're doing is setting blocks of an hour. So it'll be a kind of first come, first served in terms of people's schedules on those days. But we're asking of people to expect an hour, and that's not all. It's not all talking. It's prep, and then and it will be very fast paced.
And Teresa, can we get your email address so anybody could contact you directly about that?
Absolutely.
Okay.
Teresa, Teresa .Ruano, RUANO @calbar.ca.gov.
Thank you.
Thanks.
And I'm sorry, the dates again are
It's San Francisco on the 17th.
of next month.
Oh.
This month. July? July?
No, this
June.
month. June
June.
17th, San
Ooh.
Francisco. June 21st, downtown LA.
Thank you.
Sorry, your address, teresa.ruano
.ca.gov.
Well, maybe Elizabeth or someone we can send out Teresa's information.
Thank you.
And I just wanted to have Elizabeth give a brief update on the presentations, the Law School Assembly, and the Judicial Diversity Panel that just happened 2 days ago at our Pathways Conference in San Francisco.
Thank you. This is Elizabeth Hum with the Office of Access and Inclusion. So on May 7th in San Francisco and May 8th in Los Angeles, the Law School Assembly was held at the State Bar offices. We had the opportunity to meet with many law school deans and discuss law school support programs and programs to support diverse students. I'll go into later more detail about some of the data that we've been collecting, but we also had presentations by Elizabeth McGriff from UC Hastings LEOP program and Cindy Archer from Loyola Law School's first generation programs. And we had lively discussions in San Francisco led by Judge Brenda and in LA led by Judge Holly. And I invite them to chime in to what they thought
I think
about
we
that.
were less lively in Los Angeles,
Okay.
but other than that, the one thing I wanted to talk about was the UC Hastings program. I thought was incredibly just comprehensive, and literally everything. Because I'd come in thinking, oh, this is all going to be a lot of window dressing, and what about this and this and this? Every single question I had was answered by that. But then I thought, isn't Hastings bar passage rate low?
Yeah, and we looked at some of the data that I can go into in more detail later. It didn't show any kind of significant retention.
Right. Yeah, and which is interesting because the one thing I had been thinking is that the program that they talk about, at least in theory, and obviously it needs to be discussed as to whether it works or not, but it definitely had a lot of really great aspects to it, and it would be great if somehow that could be put down, made available on the website, sent out to law schools. I also, again, in LA, I just didn't get much sort of buzz from that. It was like, oh, okay, well, you're going to do that. I didn't hear, and in the discussions that I had, I didn't hear a lot of concern about retention of minority students, frankly, from the schools that were there. But that being said, I think that the programs, to the extent that the programs can be set down, that there, if there would be podcasts, if there would be something that would be available so that a law school could, if it wanted to, take individual pieces of that very comprehensive program and try to replicate that at their own law school, and then to sort of go out and sell that, to go to the, because it's, you know, having something on the website is all well and good, but if the schools don't, if you don't sort of push it on the schools, it's not going to happen. So I think it'd be helpful. I mean, you know, one of the things that, you know, with those programs, if we could have that put down, you know, I'm going to be up talking to the dean at Berkeley on Thursday, and it's something that I want to talk to him about, and maybe we can talk about, again, spreading it around through the other schools in California.
We did have a lively discussion in San Francisco. It was interesting. I think one of the the deans mentioned that he would really like to have that program available to all of his students, which is all fine and well. Though I think our concern was trying to make sure we increase the retention and the success of, of law students of color and women. But I thought it was good. I thought it generated some good conversation, good discussion. I was very, very pleased with it. I really don't have much to add.
I did also want to recognize that that we appreciated Esther, Catalina, and Donna that joined the Law School Assembly. Part of the reason that we wanted to incorporate COAF in the Law School Assembly was to share the information on the productive mindset known as bar studies and strategies information, as well as some of the other activities that the bar is doing in order to support the diversity inclusion initiatives. For example, reviewing its moral character exam, moral character admissions, talking with the schools to understand what have been some of the barriers for people that have had criminal records from just getting dissuaded from applying to law school, and how inconsistent some of the information is from the law schools themselves, as well as what the bar is asking, to make sure that that is more consistent. So a lot of this is happening on multiple levels in different areas, but addressing the idea of getting information through the schools and understanding more what those barriers are for different populations, and then incorporating some of those best practices throughout. I did want to follow up because I did find my notes on the bar studies and strategies information to give you more information about what the control group learned from the bar studies and strategy session. The control group learns about time management and organizational strategies for effective studying, and importance of gathering and using study resources to prepare for the bar exam. These studies are commonly known and helpful and can be found in a number of places, but the control condition essentially reminds students about these kinds of common study strategies. And this is coming from Victor Quintilla, the lead researcher on this. In terms of what the intervention population received in the 45-minute session, they get an introductory film, audio and written stories about prior test takers, and the module in which participants wrote letters to their future test taker selves to how to use these stories and insights. The more that the student seeks to help others with these insights, the more they find themselves benefiting.
All right. Thank you. There were a couple of things that I want to talk about in connection with those matters. I felt like it would be great if in the future COAF, its membership as well as leadership, could be involved more in the planning for things like the law school assembly and any kind of diversity conference. I think, and part of it is just a question of timing, I understood, but there's sort of a feeling of, you know, we get asked to speak, which is wonderful, and we appreciate the opportunity to do so, but it's like, oh, we didn't know there was going to be this or that. And like the event on, when was it? Wednesday. Like I said, I'm still in Cairo, but yeah, I think we could use our COAF resources for example, to plan what panels would be best and how you do things. I think that would be very helpful in the future, and for example, for the law school assembly, I was, as I said, the retention program I thought was really great. I thought the panel was wonderful. There were a lot of great ideas. On the one on criminal records, I thought, how many people are we talking about? We're not talking about that many people. Is this really something that we're going to have an entire hour on talking about people with criminal records applying to law school? But as I said, it's just a question of planning beforehand to talk about what it is that are of primary concern, I think, to the attendees. But as I said, I think the programs were wonderful, and I think they were very helpful. It's just that I thought, gee, it'd be great if we could use the resources of COAF to be planning these things throughout the process. So that was just my thought on that. On the hearing before the legislature, I thought that went very well. It did, as Justice Liu told me later, get a little hijacked on cut score. And that seemed to be a lot of what the legislature was interested in. But certainly there was a lot of interest in all the diversity programs that are going on. And we did have the opportunity to talk about what it is that COAF does and what the State Bar is doing to increase diversity in the profession and on the judiciary. So thank you for that opportunity.
And this is Judge Harvin Forte. I'll join in Judge Holly's request that we be more involved in the planning to solicit our ideas as well, particularly given the history of some of the things that COAF specifically has been dealing with as relates to law schools specifically. Because since COAF was formed, we've been talking about things we can do, how we try to change what's going on in law school, change the attitudes, change the perceptions, and really change the outcome and make for better outcomes. So it would be good for you to tap in to our experience and our expertise as you plan those, and so that we can focus more on things that we think might really make a difference.
Do we have anything from anybody else? No?
And I just want to also just one final thing. It was so good to have Catalina. Oh, I'm sorry. All right. It was really good to have Catalina there as well in San Francisco to kind of spark discussion and some things that helps to bring out some good and positive information.
All right.
I would also just like to say, for those of you who don't know this,
It's better than it was.
so just for those of you who haven't been around a long time, and I don't know if this should be talked about later, but COAF actually sent me to two panels. The Supreme Court in 2017 convened two panels through the State Bar for the cut score, and I sat on both of those panels. Only 3 of us sat on both panels. One was 10 lawyers, the other was 20 lawyers. And it was in response to the letter from the deans from the law schools about the cut score. They were called the Content Validation Study and the Standard Setting Study. So there is a bit of history and institutional knowledge that we have here. And I did see later on you're going to talk about volunteers for work groups. I really hope that I will be considered to be on those groups, because I have been involved with the law schools, with the dean's cut score concern, and I would hope that we could continue that, to not fragment it.
Thank you for the feedback. The Law School Assembly was actually reorganized this year in a way that included a lot more departments than just what's happening in the law schools. It was much more interactive, and it was the first time that there was a lot of different panels, and so I will definitely take that feedback in. The one thing that I would like to, that hasn't been necessarily, that I wasn't necessarily as aware of, was the moral character application regarding people with criminal backgrounds. And I see a direct connection because we know that people of color are disproportionately arrested and have those records. And so I see that as a direct correlation in terms of how it impacts our law school applications as well as the retention, because some of the comments really were about, once they are in law school, the fact that there is even a bigger sense of lack of belonging and peer support. And so As I become more familiar with this, I think I will be able to help support some of that navigation amongst the different offices in the state bar, and that is the goal, right? That the diversity inclusion principles and our objectives are throughout the state bar, and how do we promulgate those practices and those values in all the aspects of our agency.
Just wanted to clarify a few things. So the Law School Assembly has happened annually, and it's put on by the Office of Admissions. And so I think, Helen, when you said this is the first year it's not law school focused, the clarification would be this is the first year that any other office besides admissions was asked to provide input as to what would be on the agenda. And it is in the law, alignment with what Helen identified, really trying to make sure that the principles of D&I are fully embedded throughout the organization, not just housed in one part of the bar. So I think we can certainly improve. This was the first year. But with respect to the moral character working group, the genesis of that working group is well beyond dealing with issues of folks with prior criminal records. There was a concern that was raised during the sub-entity review process that we underwent maybe about 2 years ago now, about the lack of transparency in our moral character process overall. We don't have published guidelines that are clear, that explain to applicants what standards and criteria we use to determine whether or not you will be deemed to be of good moral character. And that was identified as not being a best practice. So that's the overall project. And within that, we of course need to look at the very important issue of how we deal with folks with prior criminal records. And I would say that it's more common than you might think that we have applicants with some criminal history. Not saying it's the majority of applicants, but it's certainly more common than I thought looking at the data set. So
I'd be interested to know what the actual figures are. That's
yeah. And we can't give them to you, unfortunately. We just launched a true case management system in admissions February of this year, if you can believe that. So the way we've had to tally these things in the past has been manual. So I can't give you the actual percentage. I can tell you from random samples that we've pulled what the approximate percentages are.
interesting. All right, so I guess Helen and or Donna are going to be giving an
Before
update.
we move on,
Oh,
Judge
yes.
Holly, can I just
That's
wanted
fine.
to acknowledge both Judge Holly and Judge Brenda for being on our panel at the Pathways to Justice conference, which happened earlier this week. It's a conference that the State Bar holds with our partners at the Judicial Council and Legal Aid Association of California for legal aid attorneys and advocates and the self-help court staff. And so they put together a panel called Demystifying the Judicial Appointments Process, and they were able to have
We had a great
wonderful
panel.
discussion. Justice Jenkins, who's the Judicial Appointment Secretary, was able to join in, as well as Judge Bachigalupo from the LA Court, as well as the Jenny Vice Chair Minder Singh. And so it was a really wonderful discussion, and I think the audience really appreciated all of your perspectives and experiences. So thank you.
It was a very well-received panel. Thank you, and thank you for your help in putting it together. Yes, yeah, absolutely. All right. So anything else?
Nope.
All right.
Thank you.
So, update on other recent Board of Trustees actions? No? No? Okay. Now we have a discussion on the results of the Attorney Demographic Survey. Caroline?
See if we can cue the presentation. So while they're setting it up, in January of 2019, so January of this year, the State Bar rolled out a demographic survey during the annual fee statement period, where a large portion of the attorney population will go on to the My State Bar profile on the as part of the State Bar profile and be prompted to complete a survey. And the demographic My State Bar profile survey was completed by over 125,000 attorneys. So that number continues to grow as some attorneys, as we have newly admitted attorneys coming in. But for the most part, we have a very large number of attorneys completing this or have completed the survey. In the design of the survey, we reached out to volunteers from the affinity groups that participated in the August 2018 Diversity Summit. In addition, we received feedback from several board members who reviewed the survey as well to provide feedback. And so there's several slides that we want to review today. So we're going to try to do our best to. Oh, sorry. Yeah, so you want to hand out the copies? Yeah. Okay. I think they're right under here. Everybody? I thought I did. Oh, I guess they're still upstairs. Oh, I'm sorry. Okay. I'll go ahead. Apologies about that. Okay, Joseph. So while we're still getting set up, some of the slides I think folks have seen regarding at least the population. So just to know, this is just a snapshot of the data. As we mentioned before, this information is continually being collected throughout the year, so some of the percentages might change very slightly. But for the most part, this represents over 125,000 attorneys who completed the survey. And just high level, what we notice is that for California attorneys, the California attorneys in terms of population comparison to those in residing in California that 18 years and older, we find that for California attorneys is predominantly white, with 67% of the population identifying as white, 12% identifying as Asian.
Hold on, Carolina. I don't really. Where's the PowerPoint?
So we're trying to set that up now.
He doesn't have it.
We send it to you right now. Okay.
So let's get that together. All right.
Okay. Back in production. Sorry for that delay. So again, as I mentioned, this is a snapshot of our current data that we have on attorneys. So one thing that we would note is that the population of California attorneys are represented predominantly by 67% white attorneys, 12% are Asian, 6% are Latino, 3% are Black, and 12% are identified as other group. In comparison to the California population, which is much more diverse, with a Latino population of 35%, an Asian population of 16%, and a Black population of 6%.
So just before you go on, I think if you go back.
Yeah, sure.
I think what was really interesting for us is to see that, yes, there's significant underrepresentation of all people of color, but that underrepresentation is not the same. And certainly when you look at the Latino population, that disparity is incredibly large. Between 6% of the attorney population, 35% of the state adult population. So just wanting to highlight that I think it's important that we do focus on those distinctions to the extent that they make sense. And we're going to see some of the other areas in our survey data where there are important distinctions between different non-white racial groups as well.
Can I ask one question? And this is really, really minor. But is there a similar type demographic that can be used in terms of California population of, say, 25 and over, which is what you would expect people who could be old enough to be lawyers to be? I mean, I doubt it's that much difference, but I just thought, I looked at that and I thought, 18.
Oh, yeah, we can look at the census in terms of 25 years and older. The percentages are going to be just
Yeah, I figured it would, yeah.
slightly different,
I
but we can look
figured
into that, yeah.
it'd be very close, but I thought that's sort of the demographic, really. Yeah.
The reason that we've done it this way is that the board at its planning session, as you may recall, sort of grappled with this question of what should the diversity goal be.
Right.
And the long-term goal was to match the state population. They didn't even say the state adult population, because if you went all the way to 0, these numbers would be very different also.
Right, yeah, but that's what I'm
so-
thinking, is that it is slightly different with basically the available people who could be attorneys versus otherwise.
Okay.
Just a thought.
So our next slide reflects the population as identified by gender. And one thing to note is that the census does not currently provide non-binary options for identifying gender. But however, the new demographic survey that the State Bar has rolled out does. And what we found was that the attorney population is predominantly male, but we also see that there is a percentage of the population that did identify as non-binary. We also collected information on attorneys by sector. What you'll see throughout the presentations today is a majority of the attorney population is working in the private sector, with government being the second largest group, and then nonprofit the third. So the next series of slides will be focusing more on the private, government, nonprofit, but also very closely to the private sector. Yeah, sure.
Clarification. So, and I'm kind of going on remembering when I went online to pay dues, this survey does not include those who are inactive members of our.
I don't believe, unless they are inactive attorneys, pay
They still have to
Yes,
pay.
it does include. It wasn't limited to people who are active.
yeah.
Okay, I don't remember like having an opportunity to do the survey, so that's why I was wondering whether inactive or.
Well, we launched it not until January.
Oh, okay, I paid
Yeah.
earlier.
You paid, yeah,
Yes.
you weren't in the last minute rush.
Yeah.
So
So
we
this is-
missed a group of folks. This year, we will do it right at the beginning of the billing cycle.
So you caught the procrastination.
Right, so this is the procrastinators group. Okay.
Or the people that went back on to print out a bar card. They may, meaning people whose firms paid, but then they go on to the website to print out their bar card.
Interesting.
So several, yeah.
Markers don't get sent out.
I don't believe so. So just a clarification, anyone who has not accessed their My State Bar profile would be prompted to complete it. So if you were paying as an active or inactive attorney, or you are going to do an MCLE, so essentially anyone who has to access the My State Bar profile that has not done it before will be prompted to complete the survey. And yes, to the point that Leah made, it was rolled out towards the end of the fee payment period, but also that's a large portion of attorneys that pay it towards the end. And what we see here is the breakdown between the three largest groups in terms of employment concentration. So we have private sector, government, and nonprofit. And what you see in the other slides to come is that you do see a large number of white attorneys represented across all. However, you see a more diverse population in nonprofit and in government. So similar to the slide the slide before, seeing how that breaks down with race, ethnicity, looking at race specifically, you see across all races, a majority of the population is focused in the private sector. Now, looking closer to the private sector by race, you see that, again, not only do you have a large number of white attorneys represented here, but you also see that across race and ethnicity, these attorneys are working in a law firm setting. Interestingly enough, you see that for solo practitioners, you see a large number of Black attorneys in that type of setting versus the others than corporate. Now, when you look at gender across the different employment settings, you see it play out a little bit differently, with a concentration of female attorneys working in the nonprofit sector and then in government. This slide goes into more of a, did I miss one? So looking at male and female, again, and the population being centered in law firms. And then when you look closely to the law firm population, and you think, and we asked the question regarding partner, associate, there were a list of options to identify your sort of job level. We found that a majority, again, of those in the law firm are white, and of those who are partners are also majority white as well. When looking at partner, associate, and other, again, you see a majority of the associate population is attorneys of color, with Latino and Asians being the top, having a higher portion, and then followed by Black attorneys.
Can you go back a slide, Carol?
Yeah, sure.
Because I think you need to be clear about how to read these
Okay.
these slides. So this slide here is telling you that 70% of partners are
white.
This is your law firm snapshot.
yeah,
Mhm.
but this is telling you that of partners, 75% of them are white, and of associates, 60% of them are white. Is that what that's telling you?
No, this is just looking at,
Kind of
so,
looks.
so, I mean,
Just partners.
for white, the count is 75%.
Of all partners are white.
Yeah, and then for the next group is for associates, it's 59% for white.
That's not the slide that's up there.
Yes, this is the slide.
Yeah,
Oh, okay, the associate is in
59%.
red.
Yes,
I see.
it's
Yeah.
a red. What? So those are the red is white associates.
Mm-hmm.
So of other positions in a law firm, about 67% of the other positions in a law firm are white.
Yeah.
So that's okay. And then if you go to the next slide, just
sorry,
because this is
can I
confusing.
ask one thing? There's kind of two levels of other, I think. You have like contract attorneys. Are those included in the other? Because if you've got contract attorneys, you've got of counsel and counsel. So I look at that as contract attorneys are really not sort of on the pathway, but counsel may or may not be. So
in the survey, we allowed attorneys to identify if they work specifically in a law firm setting or if they are consulting in
but
or
like-
they work in-house counsel.
no.
The
Within a law
other
firm,
within a law
here,
firm,
within a
okay.
law firm, you may have contract lawyers
It's of counsel.
who are just getting paid a salary or not on the path towards partnership. People who are of counsel or counsel may be either on their way to partnership or on their way back from partnership or, on a holding pattern.
It's of counsel and staff attorneys, if
And
I recall from the.
yeah.
It's not contract attorneys.
Well, staff attorneys are the same type of thing. They're not on the path. Those are not.
Well, it wasn't limited to people on the path to partnership, but it was looking at, are you employed by a law firm, not
Right,
as a
yeah.
contractor? So that's what's in the other category.
Right, I just thought that it might be helpful to break out a little bit as to whether you're staff or contract, or whether you're counsel or or something like that. Just in the future, I'm not saying it's.
You can't really say employed by a law firm because a partner in a partnership
Right.
is not an employee; they're an owner.
But I think that's
But
understandable.
I mean, if you're trying to say that they're employed and that's how they get counted, it's not.
I assume people who are partners.
Well,
would
we
say that
can
they're
put up
with
the
a law
actual
firm.
survey questions maybe a little bit later. We do have, I think we have the ability to put those up so you can see exactly what was asked. But if we go to the next slide, because they're just to be, so this slide is different. This is saying that if you are white, 49% of whites are partners. So virtually 1 out of every 2 white people in a law firm is a partner. Whereas 35 or 33% of Latinos are partners. 30% of Asians are partners. So this is a different way to look at it. It's like within your own racial group, what is the likelihood that you will be a partner? As opposed to the previous slide, looking at it in totality. So that, Catalina, I think is important that you're clear as you're going through these, that distinction between how to read these slides. That's why there's a footnote.
Oh, that's happening. Okay.
So any additional questions on these? Okay. Okay.
I think you
In
need
the
a,
last line, the other, do we know how many attorneys that is, or what percentage of attorneys in firms that is total?
So the slide, so this previous slide for partners.
It would be the
The
slide
other
right
rate?
before this one,
Oh, so right before this one?
I think.
I asked for those who may be on the phone or I think we should identify the specific slides.
No,
we're
I'm
looking
sorry,
at.
I think I messed you up. It's the race one where we have the partner, associate, and other as the 3 colors of the bars. Yeah, that
So
one.
partner, associate.
I'm just
and-
curious how, I feel like you're jumping 2, or they're in a different order than my sheets, one or the other. But the one that had 3, it said law
Why
firm
don't we-
snapshot race at the top, and
I
then it
think
had
they have
3
numbers on the bottom.
bars.
They have page numbers on the bottom?
In mine, it's the one, 11.
Slide
11,
12.
okay.
So it was one.
Slide
Okay.
12
She
is
said
on the
11.
screen.
Okay.
Do
So
you want
the-
11 or 12?
I said it's 11 on
Okay.
mine.
So is this the previous one here?
Yes.
Okay.
So that one, the other, do we know like what percentage of attorneys at firms that is total?
So I don't have the total percentage, but we can most definitely provide that for you, yeah.
Okay, I mean, I'm just curious, is it like 2% of all attorneys in firms, or is it 50%? I mean, I assume it's not 50, but you know,
I mean,
like
it's
how small of a percentage is it?
That's what's odd is that you got under that, so there are more other as opposed to partner and associate, and what, there are more white others?
No,
No.
I don't think that's how.
No, so the way that you read it, it's so when you read from left to right, you have white, and then the first bar is partner, and then associate, and then other.
Right, so there are more others than there are associates.
No, so other is a different type. It's so you have the opportunity to select partner, other, or a different type of job level type.
So if I can just clarify, when we're looking at what these categories a person could have chosen, it would have been partner, counsel, associate, staff attorney, law clerk, manager, administrator, a non-attorney position, or other. So in order to
That's big
simplify,
differences.
the presentation of what positions are held by what demographic background of a person, we just collapse it so that we would have partner, associate, and then other, just for the sense of within that racial demographic.
Right, but it does make it look like one of the most important categories. It's more important in the other, I think because there are big differences within that other category.
Yeah.
Maybe that does need
Yeah.
to.
So we could take
broken
note of
out.
that in terms of when we lay out the data in the future. So because the purpose of this slide is to really highlight the disparity in the partnership versus associate levels. And that point is carried on in the next slide.
I was gonna, this is
Oh,
Judge,
sorry.
Judge Brenda, I was gonna say, you could drop a footer, a note that says, other includes, staff
Right,
attorney,
yeah.
all of those things.
Right.
And then at least people know that,
Yeah.
that bar represents a composite of a number of different
Yeah,
categories.
because that's sort of, the way that's set up, it sounds like it includes people who are really not acting as attorneys at all.
And this is the
Just
feedback that we would
administrative.
like from the co-op members, right? So this is partly, this is the initial snapshot. I mean, this has been updated since the presentation that Highland Chen presented to the Assembly Judiciary, but data, as you know, is still coming in. The categories that were developed were by some of the ABA, as well as some studies that were identified for looking at ethnic demographic breakdowns, including the study by Justice Goodwin Liu in terms of Asians within the field. And so we have a lot of data. Part of this is to show you kind of what we're seeing from the first glance at it. Yeah.
So another thing that would be helpful as you continue to give this presentation, it seems like white, Latino, Asian, Black have a specific color, but you're also using those same colors to, it
Right,
gets
for
maybe
the
on some
partner
of the
associates, so it's a little
yeah,
confusing.
so for me to be able to keep with the color to an association as the different graphs change, I think it would be important that the other types of indicators also have their distinct colors.
Yeah, so again, we'll take note of these and modify the layout so visually it doesn't create questions and we could focus more on what the disparities are highlighted in the charts.
Yeah, and just, I don't know if it helps or not, but when I first saw that other slides and I saw other, I thought it was staff, like secretaries. That was just my first instinct. So.
And I think
the
Footnote
would
with the
probably help.
definition, when you put other, a footnote that says other includes A, B, C, D.
And I think what would be valuable too is if and at some point later on today is to go through the survey to also see how they associate to some of the charts, or at least some of the high-level questions that we were trying to answer here.
And I think we'll be going into this in the work groups themselves. And so this is part of like the big picture, and this has been evolving. The first version, we had done it by ethnic races in terms of positions, and it looked like it was higher, but that was because the top rank was 8%. And so this is the second evolution to kind of show comparatively to the positions themselves to show what that gap looks like. And so I do want to give that context. That is a working document. Thank you.
Okay. So our next slide here, we reviewed the breakdown between partner, associate, and other. And as we mentioned before, the other group is the other attorney type positions that were listed in the survey. And here we see that a large portion of the associate population is attorneys of color, where a partner, you have a larger portion of white attorneys represented here. Now moving into a focus on attorneys by gender, we're looking at law firm partnerships and how they are broken down by gender. And here we indicate that a majority of the attorneys are male that are also partners. When looking at associates, you see there is a closer parity with male and female proportions being slightly very close. Here we have another look at the partner and associate comparison. And so when you're going left to right, we're looking at the blue, which is male, red is female, and then the darker blue is non-conforming. So what we see here that men are, again, much more likely to be partners, where women have a larger percentage of the associate population.
I have a question. How can there be that many non-conforming partners? That doesn't make any sense. With the percentage
Has joined the conference.
non-conforming is 40%?
Well, it depends on how many there are.
Yeah, so we have the raw numbers is a smaller number for non-conforming.
So let's say
Yeah.
that there were 10 non-conforming partners, 10 people, okay?
10 people
Then that
total or
means
10
that
conforming attorneys?
About 4 out of the 10 are partners, about 4 out of the 10 are associates, and about 2 out of the 10
So it's just a much, it's a much smaller population.
So when you read the slide, it's the percentage for each group within each group. So I think in the future, what will be helpful is also just maybe provide some of the raw counts too, so you can have that in comparison. So the next slide, we're looking at both race and gender. And so what we see here is the red bar representing the proportion of white men in comparison to partners that are white women, Latina women, Asian women, and Black women. So as we've seen in previous slides, is that the partners are majority male, but what highlights here is that in the partnership for women, there's a higher percentage of white women as partners. In the next slide, we're looking at career advancement and again, associates. And here, different from the partner slide, we see that white men are underrepresented in associate, where a larger portion are women associates. And here we also see that in the difference with partnership, associates of color, Latino women, Asian women, and Black women have a higher proportion here. This slide gets a little bit closer in terms of how do you look at the breakdown of race of attorneys across firm size. And what you see is that regardless of the firm size, you still see a predominantly large number of white attorneys represented here. Now, what we were able to do is look at the NALP data to see how we compare to national trends. And the NALP data is in blue, and the California attorney data that we collected is in red. And so what we see is that at the national level, we are doing slightly better in terms of our percentages of partners that are women and non-white, and also non-white women. Similar in our associate population, we see that 50% are women compared to 45% at the national level, 41% non-white for California, where 24% is at the national level, and then 22% for non-white women attorneys in California, where 3% are for national level. Again, another comparison, what we see is that for Asian, Black, and Latino, women have a higher percentage in terms of partner in California compared to national trends. For associates, when we're looking at California compared to national trends, we see that, again, California is doing better in terms of for the Asian population. We're slightly under for Black attorneys, but we do have a higher percentage for Latino attorneys.
And this is something I raised before, and I'm sure it's going to be addressed, but the thing about these charts is that I know there's 2.7 versus 2.0, and they come out as different, but when you have the numbers just as flat, it looks odd that 2% here is not the same level as 2% over there. It's very odd.
Yeah, so I think we're taking note of all the sort of visual components to make sure that in the next iteration it's a bit clearer. And then in terms of retention, the My State Bar Profile Survey did not only just capture demographic information, but it also captured employment type, the setting, the job level, but also the experience of attorneys in their field. And in looking at terms of overall satisfaction, broken down by race, we see that a majority of attorneys are satisfied. However, you see lower satisfaction levels for Asian attorneys and for Black attorneys. In terms of satisfaction levels for men, women, and non-conforming, you see a higher percentage for men with the lowest percentage for non-conforming. This is interesting that we see for the breakdown in age, those attorneys who are more senior have a higher satisfaction rating than those who are new to the profession. I'm sure many of you have thoughts about that. And then when we look at the breakdown of race across firm size, this is only one of the two slides that include this. What we see is the white population represented in the blue bar and the Latino population represented in the red bar. And that demonstrates those populations with a higher overall satisfaction rating. Whereas And one thing to the slide highlights is that in the 100 firm sizes with 100 or more, 101 to 200 for Latinos have a lower satisfaction rating.
And so as we go through this rich data set, you can see that we've been trying to cut the data, really thinking about not only the ethnic breakdown, but also how that also is impacted by age, type of employment, and the size of the employer themselves. If we know the majority are private, for example, I had assumed that the smaller firms would have been more diverse, but the data shows that that's not true, that that disparity exists regardless of firm size. And so when we look at this data, it really is an incredible robust set of data that we have that we're able to try to correlate to better understand what are the disparate issues that come out based by practice, size, and race, as well as what are areas that I think may have special areas of interest for some of our affinity bar partners, as well as best practices for specific types of employers. And so I just want to say, like, this is a lot of analysis that we've been trying to do. The age actually came out from Judge Fuje, who had asked, well, what does this really look like for the different ages, thinking that the satisfaction is really different based on age group and what that looks like based on race and ethnicity as well.
And when we go to looking at for Asian and Black populations, we see a lower percentage rating in terms of overall satisfaction. For Black attorneys in smaller firms, you have a 59% satisfaction level.
And I know this is totally off topic, but it would be interesting to see at some point, and this is not necessarily our job, but job satisfaction levels for other professions to compare them to lawyers. Because if everybody's unhappy, then we're all okay.
Yes.
That's my thought.
Retention, right? And there are some studies that show women of color in particular dropping out of the profession after about 8 years. We will soon be launching a survey when folks go to voluntary inactive status, asking them why they're doing that. Why are you choosing to be inactive? So we can begin to see what our own patterns are here in California and why do people drop out. So that's the, like, if everybody's unhappy but they just stay in the job, maybe we don't care. But if people are unhappy and then they drop out of the profession and it impacts the overall diversity of the profession, then we would care. Some of the things I think are so interesting about this data is Asians are the least satisfied with the profession overall, and
it's because our parents make us go into the profession. That's why.
Or it just is it.
That's true. They're unhappy no matter what.
So it's again, I think it's so interesting when you get the data and you're able to look at it, and as Helen said, you know, just in this real disaggregated fashion and understand the nuances of what's going on here.
Can I ask you? And I should know this, but you know, you've got active, you've got voluntary inactive, you've got voluntary inactive who we don't want there. Is there also just people just drop out? I mean, because inactive costs something, right? So if people just, I think that's an interesting demographic as well to find out why, if they're completely resigning from their bar membership voluntarily and not because of discipline or something like that, why is it they're doing it?
I'm gonna say, I was looking at Donna, it's a really small percentage because you can't do it easily. And once you do it, it's not easy to get in again. So I think paying the inactive rate is probably something most people would select, but it's a very small number. Don't you have to petition to the Supreme Court?
Really?
Yeah.
Because when I was in when I was in family law, I had an enormous. It was interesting. Sort of there were a bunch of women who had stopped working, and as far as I could tell, they were completely out as opposed. But maybe they were paying inactive dues. I don't know. But they were not working, and they figured they were never ever going to come back to the profession because for whatever reason. But. there's also the folks who, I'm not working as a lawyer. I don't think I'm ever going to work as a lawyer again. But my brother's cousin's, third child may need help in their divorce, right? So most people go inactive as opposed to resigning because there's always the possibility that maybe I'll need to do something as a lawyer in the future.
But then they have to become active again, right?
So then
I hope.
they'd have to become active, yes. But it's as Leah said, it's easier to turn from inactive to active. That's pretty simple. Whereas if you've resigned, then you have to file an action and demonstrate that you've kept up on the law, and demonstrate quite a number of things in order to be permitted to return to the active status. It was like $155. Right.
Okay.
Thank you, sorry.
And this would,
If you go inactive.
okay. For the survey as well, we asked a series of items from attorneys' experience with their coworkers, having a diverse workplace, to their feelings about performance evaluation, to HR policies such as maternity leave, and there were over 15 items that were listed that attorneys would indicate that they were satisfied or not satisfied or neutral on. And so we've organized them in 3 large groups: collective work issues, individual career issues, and work-life balance. And those next few slides would provide the overall satisfaction for these different groups. So high level for collective workplace, you see 57% of the attorneys that responded with overall satisfaction for this category. It decreases for individual career issues, and then further for work-life balance. In terms of levels of satisfaction across the different racial and ethnic groups, we do see that white attorneys have a higher level of satisfaction in comparison to Asian attorneys, as we mentioned before, have a lower level, and Black attorneys having the lowest of levels for their career satisfaction with respect to collective work issues. And you see this play out more with the bars here, the first being collective work issues. You see the percentage low for Asian and Black. Individual career issues, again, you see the percentage low for Asian and Black attorneys. And then for work-life balance, the lowest being the Asian population. And we reviewed this similar breakdown across gender. Again, men consistently having a higher level of satisfaction, and women reporting lower levels of satisfaction. And you see this with the charts for collective work issues, women having a 53% overall satisfaction rating. Work-life balance, again, the lowest for women, 48%, and individual career issues, again, lower for around 48%, 49%. So much of this data, again, we are going to review to make sure that it's also visually digestible, but also would be helpful in developing a report card. And so I wanted to just quickly provide just a sample overview of what we wanted to just have at your fingertips in the later part of the session. And these report cards have a better visual layout than the presentation, but also can highlight specific indicators that you want to bring attention to in terms of measures that we're collecting in the survey. And so if we could cue the...
So while that's getting queued up, one of the work plan goals is really to dig into this data, to analyze the available data to particular obstacles to diverse attorneys' entry into and retention and advancement in the legal profession. And some of those areas, as we talk about later on in the afternoon in that work group, is to make recommendations for the actions for the state bar to take to address those issues, to recommend refinements in the survey, and to identify possible programs at firms and agencies to develop and disseminate best practices. And so a report card is one of those tools that is also in the objectives that might help spur some of these actions to help highlight what are particular issues that different types of employers and practices might be able to make an impact on in terms of now moving the needle now that we have baseline data.
So very quickly, we have an example from NAACP, who looked at different banks. We have an example here on academic report cards that demonstrate different types of graphs and percentages and indicators. Another one on components of a Harvard Medical School review. One looking at inequality measures. One looking at gender inequalities in the political setting in other countries. And then one looking at gender diversity within a specific profession. So again, these are just samples to have at your resource to review. Oh, sorry.
Talked about this, Judge Fucci, when we looked over the data, is for COAF to think about is the bar strategic plan identifies the objective of publishing a report card by January of 2020. So really looking to COAF to figure out what the format should be and what should be on the report card. As we discussed, I think, we have a big enough data set to do some more drill down report cards. Like we could even do report cards on specific large employers. That may be too aggressive, but we could do it by comparing sectors or comparing law firms by size to one another. So something to think about. Certainly we need a statewide report card, but are there other drill downs that you all think would be appropriate? The goal is to put some pressure on in a way, again, that's sort of acceptable. Like I don't personally think we're going to be able to call out specific law firms, but maybe you all think differently. So we do have enough data that we can think about drill downs on the report cards.
One thing I'm sorry, this is Holly, was thinking at is that in terms of, we need to show the legislature that we are making headway, and that because of the numbers that are involved, it's difficult to say, oh, it was 3.000 whatever. I think perhaps what we need to be thinking about is ultimately when it comes to putting together that report, to the extent that we're able to show any increases, to be able to show percentage increases of what it is then. So you're not going to, saying you're probably not going to go from 3% to 5% of X numbers, but
joined the conference.
3% to 4% is a big percentage gain from that, and really that's what we should be. I think this is it makes it easier to show gain than it is when we're just looking at the sort of overall figures, overall percentages, especially if we're working on a year-to-year basis.
And I think that I guess I was having a little trouble with capturing it as a sample report card, because when I think of a report card, it's some entity either doing something good or bad. And so to your point, if it's to be framed as calling out certain law firms, then I can see how it could be an actual report card with a grade scale. Otherwise, the last three examples, I would say more so look just like fact sheets, just how things are. And I would, if it's really just to capture the data that you just shared, I think the last three examples, as opposed to a grading scale, unless you're calling out a specific set of offices, would be most appropriate.
But we could be sort of calling out the profession as a whole. So the benchmark or the grading scale, if again, the goal is to achieve parity with the state population, that's what you're rating against. So you could be we're grading and evaluating the state of the profession. And so we expect to see movement year to year. We'd like to see these numbers improve. That's one way to do it with a grading scale. Like right now, we might give ourselves an F. I don't know, but we might not give ourselves a very high score. But we'd hope to see improvement over time.
Yeah, and I'm just wondering, in that instance, who would be the responsible party? Like, is it? I'm not saying, but like, is it the state bar, or is it what is the entity that is responsible for that, holding that grade level?
I'm sorry, for changing it, for.
So when I think of a grading scale, it's like some responsible group has done something either so well or so poorly that they've received a grade. And so I'm curious, like, who is the responsible entity if we're using a grading scale? Like, who is this reflecting back to?
I think, so, and sort of putting together with what Leah was talking about, which is that I really don't think that we're talking about individual law firms. I think that would, we all know how law firms respond to individual attacks, and that's not pretty. But if you had, law firms 250 and above or something like that, showing, and also, it's not just saying, hey, look, you've got a D or you've got a C or you've got an F, but saying these programs are available. You can do this to increase. We'd like to see you get that grade up, and this is what you can do to do this, and the State Bar will help you to do that. I think is really what's it about. It's not so much did they get an F as let's get that grade up from an F or a D to a C or something like that, and also to be able to show gradations again, because they're not going to just all of a sudden say, okay, you know what, all of our minority associates are going to become partner today because we want to get our grade up. So I think that's one way of doing it. And so you got government offices, you've got large firms over X, you've got firms of 5 to 10, you've got solo practice. I don't know how you make solo practice more diverse.
But there, and I would just also add that their responsible entities are multiple. Just like I'm sure, I haven't even looked at these, but if you're looking at political participation by women in a country's system, there are multiple responsible entities. So it's not just one, right? It's the law schools, it's the state bar to the extent that we can do things to improve diversity, and it's employers. And certainly where you have more of the attorney population mirroring the state, like with Asians, for example. It's a little less, but it's close. Then you see big disparities in partnership. That's the employers. That's really clear. Where there's a huge disparities even between the attorney population and the demographic, like with Latinos, that's a little bit different of an issue. So I think there are multiple responsible parties, and publishing the data and using, whether it's a fact sheet or a report card, but it really begins to enable people to ask those questions and then talk about who's doing what to address all of these different issues that have been identified.
I would really like to see if there is a report card done, and if it is either statewide or by I want to say industry, but like Judge Fujier said, like firms over 250 or whatever. I think it would be really great to put either a paragraph or a footnote or something that said, want to see if your firm is passing. If you have this percentage and this percentage and this percentage and this percentage, then you would be considered passing, or you would get an A grade, or however the terminology works out when it's finalized, so that then somebody does have a little bit of data to either maybe take to their firm's hiring panel and say, look, we're failing. Like, we're worse than the state averages, and they say they're failing, so we're even worse than them. Or look, we're almost there. Maybe we could increase this. And then we're not calling out individual firms because, there's always going to be a reaction. Well, we live in a county where there's not a lot of whatever group or something. So I just think but it would be nice to have like that as a footnote, just so maybe people have a little bit of ammunition.
So this is exactly what we want from the work group, right? Like this is, it's what's being developed is based on your suggestions and what you'd like to see in order to effectuate movement. And so this is about, one, I just wanted you to understand and see how rich the data is, to see how we can cut it, but really the development of the report card or fact sheet or what have you, and the next iterations is what we want co-op to help develop. So then that way we know based on your experience, what is actually going to change behavior and what should those recommendations look like. And so this afternoon is, I hope we can dig in and to try seeing that. And so that's what's going to be happening in between the meetings, because there is so much that we can do and there's a lot of it, and understanding we want to show the legislature, we want to show the board of trustees what that might look like in the next coming months.
Data, looking at this, okay, because another thing that you gave me an idea, Judge Fujier, thinking about best practices. We're not going to call individual law firms out publicly, but we do have the ability to look at the data by firm to see, are there firms that are doing much better than others, and are there firms not just on the demographics and who's partner, but are there firms where folks are more satisfied than others? And can we then, co-op, reach out to those firms and figure out what they're doing? And would that inform then recommendations that we make? So,
and also, you know, I would say that one of the things that I wanted to mention is the CLA Diversity Awards that I've been working with CLA on, and to say to use that in terms of recommendations for awards as well. I do want to, I think it's great, this is a great discussion, and we're obviously going to be discussing this more in the afternoon work groups. We do have, lucky enough to have Greg Tanaka and Jeannie Chang from the Judicial Council, and they're going to be presenting on the update on the Judicial Diversity Toolkit. Do we have you still there?
Yes.
I am here.
Hi, this is Jenny.
Hi, Jenny.
Good morning.
All right. So can you update us on the Judicial Diversity Toolkit, please?
Definitely. Let me just make sure we can get our presentation up for you all to see on Zoom. Take a moment. We tested this, so it should work fine. Okay. Can you all see presentation?
No, don't have it yet.
I can't see it yet either, Greg.
Okay. Sharing.
There we go.
You got it?
You got it. Jenny, have you got it?
Great.
I've got it. This is, oh, well, no, it's gone. Oh, there it is. All right.
Okay.
We're all on.
All right. Well, good morning, everyone. Thank you very much on behalf of the Judicial Council and the Advisory Committee on Providing Access and Fairness for inviting us to present today to give COAS an update on our collaborative work together on the Judicial Diversity Toolkit. My name is Greg Tanaka. I'm the supervising attorney at the Judicial Council Center for Families, Children, and the Courts. I supervise our staff and work in the areas specifically of domestic violence, family law, and supporting the Advisory Committee on providing access and fairness. I also have my colleague, who you hear, also on the phone, who will be presenting with me today, and I'll allow her to introduce herself.
Hi, I'm Jenny Chang, and I'm a staff attorney at the Judicial Council, and I want to say a special hello to Leah, who was my former supervisor when she was at the FCC with us. Hi, Leah.
Hi,
and I am currently filling in for the lead attorney to the Providing Access and Fairness Committee, Kiana Williams, who's currently out on maternity leave, and so I have stepped in until January, and I'm very pleased to have learned so much about the work PAF is doing and is charged with, and happy to join the group at least till January. So just to start off, I think I'm going to go ahead and walk us through an introduction to a little bit to our work and provides a brief refresher, if you will, on the Judicial Council's role and commitment to this work of increasing judicial diversity. I don't know if I'm the person who will be forwarding the slide, or Greg, do you have the power?
Yes, I do. I will do
Okay.
that.
All right. So the first slide that you're looking at, I just wanted to remind everybody that the Judicial Council does have a strategic plan, which is accessible on our website. And one of the primary and foremost goals, it's enumerated as goal number 1, is a statement in regards to diversity and serving the public and gaining the confidence through a judicial branch that mirrors the state's diversity. And I'm sure, I know the State Bar has done wonderful work and in showing that right now that is not what we see. And the council is very aware of the fact that while there's been an increase in the amount of diversity on the branch, that it still doesn't accurately reflect the demographics of the state of California. So I know there have been a lot of leaders who are working towards this who have asked, well, what is Judicial Council's commitment to this? You know, is it stated anywhere? And I just wanted to point out that it is, and I think it's a good refresher for all of us, not only those who aren't as familiar with the Judicial Council, but even those who are currently employed there. It's like, oh, this is really interesting. I'm so happy to learn of this. And moving on to that end, so we have the strategic plan, and under that, we've got the Advisory Committee on Providing Access and Fairness, so it's PAF, as we're known, and we are the advisory committee that is looking forward to and continuing to partner with COAF in fulfilling our charge under the Rules of Court 1055, which we have several charges, and one of which is clearly diversity in the judicial branch, and making recommendations towards how to improve diversity in the judicial branch and basically fulfill one of the strategic goals, the big arching goal of that. And again, if anybody here is interested in looking at Rules of Court 1055, that is where that is very clearly stated as a charge for PAF. If you want to, Greg, if you want to move on. And I just want to let you know, to that end, as the advisory committee, we have worked very hard on the annual agenda, and it was recently approved. And one of the stated goals and tasks is what you're seeing up on the screen right now. It's diversity in the branch, and it's definitely listed in the annual agenda as priority number 1, which means that it's a must-do item versus we have a number of priority 2 items, which is a should-do item. We will be, and it's great to have it in this amount of detail, what we'll be doing at least for this year, that, and there's some accountability for all of us as the committee, and that is certainly the updating the guide, which, as we all know, is now 10 years old, and then also reviewing and considering ideas and recommendations that will come out of, the Judicial Diversity Summit, and then collaborating with COAF as we move forward. And I think this is a really great step. This meeting, thank you so much for inviting us. And with that, I want to just say that any and all of these documents, the larger documents within where these are contained, are available to the public and to everybody online. The annual agenda is posted. The Judicial Council's strategic goal is posted, and certainly, as you all know, the Rules of Court are available online should you want to do a deeper dive and go further into that. And with that, I will hand over the details of the Judicial Diversity Toolkit and the work done thus far to Greg.
You. So, by way of more background regarding what we call the Judicial Diversity Toolkit, formerly called the Pathways to Achieving Judicial Diversity in the California Courts, this toolkit came out of, as many of you know, the 2006 Summit on Judicial Diversity, which was co-sponsored by the Council, the State Bar of California, CJA, and various local bar associations. And the overarching focus of strategies and programs that came out of that summit in terms of what the judiciary could implement was collaboration with justice partners such as the State Bar and the local bar associations, as well as our own council programming on judicial outreach and specifically mentoring of potential applicants. In fact, Judge Harbin Forte, as you all well know, was a big part of that, and Pat Lee, as well, representing State Bar, were members of our first Judicial Diversity Toolkit Working Group, which compiled the current toolkit, an iteration that we have, which was published in 2010. As you well know, there were additional summits in 2011 and 2016 where the toolkit was also mentioned as a primary way that the judiciary can continue outreach to address the underrepresentation of minorities and communities of color in the judiciary. In 2016, most recently, PATH identified the toolkit as a priority to update and make it more user-friendly and take a digital-first approach to the toolkit to ensure that it would be most likely in a format to be used by judges in their outreach for mentorship programs and programs for judicial appointment, similar to the one that Judge Harbin Forte and Judge Fougier did an excellent job on the panel for pathways for demystifying the judicial appointment process, which was great. So in the fall of 2018, staff to the Judicial Council and the State Bar began discussions to form an ad hoc working group to do just that, to update the toolkit and make it an online version of the toolkit. And in January of this year, we formed a working group consisting of 8 members from PATH, in addition to Judge Harbin Forte and Judge Fougier representing COAF, and we convened our first meeting by conference call on April 3rd of this year, and then we most recently met again this month. Just to highlight some of the things that we've accomplished so far on the work plan, I mentioned our 2 conference calls together, receiving and reviewing content and updates, specifically starting with the charting the course to judicial appointment seminars, which were part of the toolkit, suggestions and tips for judicial mentoring programs for the courts to establish and carry out, and as well as pipeline programs that were listed. We have a projected completion date for the end of July of this year, and we hope to go to the council sometime in the fall to present the toolkit along with a number of different initiatives that the branch may be undertaking as an overall strategy for outreach and increasing diversity in the branch. And then in terms of PATH's work, the toolkit will continue to remain a part of PATH's annual agenda for further updates and, again, our branch outreach planning for judicial mentorship and charting the course and pipeline work within the branch. So let me go to the next slide. So this is just a mock-up of the website as it exists now, that the working group has been giving feedback and giving comments to regarding the design and how it would look as an online version of the toolkit. So let me just see if this will play. So as you can see, this is a home page. We plan to have a message video from the chief up there in the right-hand corner. We have a brief description of the background and our collaboration with COAF on this project. And then down below here, we have model seminar programs where we have uploaded various templates for sample seminars that judges and courts can carry out. We have PDFs and Word versions of the agenda templates for courts to use, as you see there. And another version of a seminar called Charting the Course to Judicial Appointment, which is also part of our current toolkit. Here you see a link to Governor Newsom's judicial appointment application itself. Should be available. And of course, COAF's own tips on completing the application for a Superior Court appointment, which we have been in discussions about, and wanting to know if that document will in fact be updated by COAF, or if that's something that the working group can help you all update to be able to share as a resource for the toolkit. Here you see the Judicial Mentoring Program page, which lays out kind of the background and structure for how courts can set that up. And down here we see the accordion menu where you can click down through a sample timeline to appoint a judicial mentorship program committee that goes through a year initially, and then also some tips for how to carry on the work beyond that time period. And then there at the bottom, there's a number of downloadable materials as well, such as guidelines for mentors, FAQs, sample letters to potential mentor judges and mentees, etc. Just fast forward here. So that's what we have so far. We're continuing to build out content with the working group, and it's been really exciting and great to be working in collaboration on this really important project that, again, we hope to have finished, at least in its first iteration, by the end of July. And so some questions for you all that we had. Again, I mentioned the tips on completing your application for a Superior Court appointment, which I believe was last updated by COAF in 2012. I think that's the version I downloaded from your website. And so I guess we're wondering if that's something that COAF was planning to update, or that we can work with you on updating so that we can share that as a great resource on the toolkit website, as well as seeing if there's any downloadable COAF PowerPoint presentations that you all have developed that we can also include as a really great resource for judges to be able to download and use as a template to do presentations for judicial appointment, as well as pipeline outreach.
Greg, this is Holly. Just going at looking at that slide having to do with the tips section. I think it would be helpful if we could at least talk to Justice Jenkins, who is the one who's going to be looking at those applications, to see if possibly we could get from him some input on that, because otherwise we're kind of just guessing. So that's just a thought that I had about what we could be doing.
That's a great idea, definitely.
This is Donna Shealy. Quick question on this. Do we have any data on how many applicants access the toolkit, use it, how many successful appointees have used it?
I don't think there's any data right now on that. Is that correct,
Yeah,
Greg?
no.
I don't think, because it's
Yeah,
just
because
been
right now the
a-
current form is just a PDF spiral-bound handbook.
No,
or
it's
toolkit.
an old version, and it was very old.
Okay.
And I don't think that there was any effort to sort of keep track of who accessed that data and what they did with it. And that's certainly something that we should be talking about, I suppose.
Yeah, maybe moving forward.
That is part of, yes, that is part of why it's so great that we're doing a digital version of the toolkit, because then we can do web analytics on and web stats on who's using it and how they're using it, what they're clicking on, and so forth. So that will be a great benefit for having it online, be able to track that.
This is Judge Brenda. Yeah, that would help as we talk about measurable results. You know, what impact these kinds of things are making. I don't know. We've sort of talked generally, even in terms of when we finish programs on how to become a judge, whether there's some survey or something we can do later on to find out if anyone attended that program. Did they apply? Were they successful? We sort of have to track and see if somehow we can measure the impact of what we're doing.
Right. Yeah. One of the things that the programs that have been held together with the Los Angeles Superior Court's Community Outreach Committee has been, we do have a list going back to 2010, I guess it was, or 2011. And I keep track of who has attended that, who has been appointed, and there are really a large number of people who have been appointed from those lists.
And you sometimes hear anecdotally, I mean, people, judges will say, you know, I saw you present a program on how to become a judge. And so, and I'm now a judge, but that's very informal. But we need some kind of way to track that.
Sort of
to gather the information, do surveys or something.
Yeah, if we could do a keep central track of people who attend those programs, and then as appointments come in, we can see keep track of who's appointed.
Yeah, that's a great idea to bring to the working group. Yes. How we can incorporate that into the toolkit for sure.
Yeah, I wonder if we could do something. With the toolkit, is to when you're accessing it, to have you fill in, you know, a little, just a short survey of who you are, your name and your job, your graduation year, your and whether you have applied. Yeah, it's also something that we probably should be talking to Justice Jenkins about in terms of keeping track with who has applied. So if somebody hasn't applied yet, but they apply later, that we keep track of that.
And some of that information may be confidential to the governor's office. That may be one issue. We can certainly ask people voluntarily to disclose. One of the other things too for the council's aspect in terms of measuring the impact of the toolkit and whether it has increased diversity on local courts is to survey the courts and have them provide report cards in terms of what they've done, how many of those programs they may have put on or collaborated with in their various counties. That would be information that would be good to have. And if we get baseline data on each county, which we do have through the Judicial Council's annual, we still call the SB 56 report, but to just track, for each county, what the increase or decrease in diversity is from year to year in those various counties.
One of the things we've been talking about in connection with the toolkit is once the toolkit has been prepared, how do we make sure that it gets out and is used by the various counties and ideas like possibly having the presiding judges of each court report whether they have had such a program or collaborated with other counties on those programs, things of that nature. Yeah.
This is Esther from
Definitely, that's all part of the discussions we're having.
Yeah, thank you.
And this is Esther from a very basic level. Once this goes online, maybe we can have a little clicker that says visited, and so we can kind of see how many people have actually visited the website. And that's a very quick and fast way to kind of track if we're getting any interest in the very beginning onto the website.
Great idea too. And along the lines of statistics and tracking, as Judge Harbin Forte mentioned, SB 56, the plan is to definitely have those have an infographic on the homepage that shows updated statistics on our report branch-wide.
Very good.
Right, and another thing we've talked about, this is Holly again, is the idea that once the toolkit is finalized and is up and live, that a link to that be sent to, you can send them to, all the presiding judges of the counties, of the all the affinity bars and the majority bars as well, to make sure that everybody is well aware of its existence, and hopefully we'll start to use it.
And the judges associations as well.
Yes, absolutely.
Yeah, the ethnic judges and women judges association and the LGBT judges association, make sure that they get information on the existence of the toolkit, so those people, so that their mentors, their mentees will have the value of that information.
Right. And maybe follow that up subsequently with some kind of survey and say to everybody that it was sent out to say, have you used, have you or your members used the toolkit? Have you put on any one of these programs? If so, can we do a further survey as to how successful it was, who your attendees were, those types of things, just to follow up and see how effective that toolkit is.
Yes, thank you. These are great ideas to bring back to the working group for sure.
And I guess
Thank you very much.
Yeah, and we'll discuss later. I mean, obviously, COAF will be working with the council on it, but if there are additional and specific things that the council needs, that you let us know in terms of what we can do to assist you and work with you on achieving the goal of
Absolutely.
having our branch look like California's population.
Right. Yeah.
Beautiful,
Yes.
rich population,
Yes, that's the
diverse
goal.
population. A mosaic of
Yes,
America.
and we
All right, I'm
appreciate
through.
we appreciate that co-op is a vital part of the goal of PATH, and not just in terms of the updating of the judicial toolkit, but also in the planning and presentation of the judicial diversity summits and collaboration on all matters relating to diversity on the bench. So thank you, and the chief and the Judicial Council for that.
Absolutely.
Thank you.
Thank you. We do look forward to continuing our important work together.
Thank you. Anything else you want to present, either Greg or Jenny?
Right.
Has joined the conference.
That's all for us.
Yeah, the
questions
one
for
other thought that I had, and that I
Has
hope
left the
that
conference.
folks here can keep in mind, is that the toolkit isn't just a standalone standard, like a isolated toolkit, but I think it's going to be a wonderful jumping off point to, we'll be coming up with a lot of other ideas, and it'll be a great tool to do a lot of outreach.
Great.
So I hope that we're really going to value your ideas and input as we develop the toolkit and then we roll it out. I think it'll be a great mechanism.
Oh, great.
Continue the work.
This is just Brenda too. One of the things that COAF had been tracking in the past as well is how many applicants of color are actually making it through the Ginny process.
Has left the conference.
And that is one of the, Ginny has to present its annual report as well. And there had been issues in the past when women and applicants of color were not getting through with high ratings from the Ginny Commission. Greg and Ginny, Greg, are you still there?
Yes, I'm still on the line.
Okay. Will those kinds of things be a judicial council component of increasing diversity, or is that something the state bar, that COAF should sort of monitor? Do you have a sense yet of who will pick up that aspect of it? It may be something that is posted somewhere. It could be posted on the Judicial Council's website or on the State Bar's website. But that's a component of increasing diversity. If we can't get people through the Ginny Commission, and we know that it is a rare occasion when a governor will appoint someone who has been found to be not qualified, we should continue to track and monitor. We know
No, that's a great question. That's something. I'm sorry. Go ahead.
we
So
have seen an
what-
increase in terms of our advocacy, and particularly once we started the statutorily mandated training for Ginny commissioners on implicit bias, that we had better outcomes for women and applicants of color in terms of getting higher ratings.
I think that we would still continue to be responsible for publishing statistics about the Jenny Commission and who.
Oh, no, it's out again.
Reports that were being maintained. I think there were some additional statistics on the demographics of the bench that COAF was maintaining, sort of beyond what, right? And so there's a couple of those that are outstanding questions that I have directly with him as to, these are reports and analyses that have been conducted historically by COAF or staff at the State Bar. How does this fit in terms of the paradigm or the partnership we're forging now in terms of who's going to do what? So that's a outstanding question that we have. We'll resolve that.
Yeah, I will say that Judge Brenda has done an amazing job at keeping track of the appointments and the ethnicity and gender of the appointees. It takes a lot of work. It's surprising how much work it takes to track down people, and we literally, she's going to the county, especially in the smaller counties.
Yeah.
The smaller counties where we don't know whether somebody has an ethnic last name because they married somebody or because they changed their name to that. We don't know. So she had to track all that down, and she did just an amazing job, to the point where the governor's office was actually calling us to find out what those statistics were.
Yeah, thank you, Holly. And Holly is one of the people who helps with that, because we get together, the ethnic representatives from the Ethnic Judges Association. So our numbers are kept basically and updated after each round of appointments, so that we don't have to wait for a whole year to find out how many African American judges, for example, are currently on the bench. Those kinds of things. So we are doing that with Holly and representatives of the Latino Bar Associations, and we have been keeping up. And I'll still do it because it's a personal project and stuff, but we would also provide that information to the COAF members. We can certainly provide it to the Judicial Council if you're interested in it, Greg and Jenny, to give you our list. We'll start keeping track of it once the governor starts appointing people.
And I wanted to say that I found out, what was it, yesterday or day before, that there are people going through Jenny now.
Yes. Oh, yeah. There are 40
So it's
openings.
starting.
Yeah. So they are starting. But we can
16 people
and
going
we can
through.
talk about that more, and maybe something. And sometimes, for example, people don't identify. Don't self-identify as any ethnic group with the governor's office. But for example,
We find
Holly
them
may
out.
have mentored that person
That's
through,
right.
so Holly knows that that's an API, but that's not officially counted by the governor's office. So our numbers, every now and then, there may be one or two off, because we know that a person actually does belong to one of the ethnic groups, but didn't identify with the governor's office. So the governor has the official statistics, and that is what we go by officially, but we also know that there may be
We're more accurate.
more.
We also track LGBT.
LGBT, yeah, and we've been, now I think that
We have a
Therese-
whole network
yeah,
of that
Therese
as well.
Stewart will be more involved, and the LGBTQ Judges Association will also help us track, so that we can keep up with that information on sort of a real-time basis, so we can have mid-year information as well.
All right, anything else? Any other questions for Greg or Jenny? Anyone? All right, Greg, Jenny, thank you so much. We really appreciate that presentation.
Thank you.
And we
Having-
especially
Thank
appreciate
you.
your very hard work on this. And we look forward to continuing to work with you on both the development of and finalization of the judicial toolkit, but also on its implementation and making sure that we make a real difference in the branch. So thank you.
Thank you.
Thank you, everyone.
Thank you all. Bye.
All right.
Bye-bye.
I think we're taking a lunch break. Yeah, yeah.
Has left the
People
conference.
here.
You know, food is an issue with COAF
Has
around. You
left
know,
the conference.
either there's not enough food or they're feeding people late or something. You know, are there
to work.
Has joined the
And-
conference.
Hi. Who's there now? No, nobody. No? Somebody else? Somebody else joined?
Who's on the telephone?
Debbie Manning, sorry, I was on mute.
Hi, Debbie. That's always tough when you're talking and you
Hi.
realize nobody understands. Okay, thank you. All right, so next item on the agenda is that Elizabeth is going to present on law school programs findings. Elizabeth.
So I just wanted to provide some more data points for you to think about before we move into our work group discussions. Entry to the profession is another priority set by the Board of Trustees, and so we are looking at law school attrition. We looked at the ABA data for California schools, and as you can see from this slide, Latino and Asian Pacific Islander students have nearly doubled the dropout rate as compared to their white counterparts, with Black students dropping out nearly quadruple the rate compared to their white counterparts. And so this is a big concern. At the law school assembly in May, we began a discussion with the law school deans about what support programs they have, and support programs specifically for diverse students. Many of the deans cited a host of reasons for this disparate impact on students of color, including financial pressures and failure to meet academic standards. Right now, in advance of the law school assembly, we did reach out to the law schools to ask for information about what support programs they have, and we hope to be able to have a data set from all of the law schools, including the ABA schools and the accredited law schools and the registered law schools. As I mentioned, we did send out a survey to all of the law schools, and so far we only have 17 schools who have responded, 9 ABA schools, 3 California accredited, and 5 registered. We are following up and hope to have everybody's information for the working group here to look at.
What is the universe of schools?
So there are 3 categories of law schools here. Those that are accredited by the ABA, which are deemed approved or deemed accredited here in California. Those that meet California accreditation standards, and so the Committee of Bar Examiners accredits based on their own standards for schools that are not ABA accredited. And then the registered law schools are neither ABA accredited nor accredited by the Committee of Bar Examiners. They are they are unaccredited schools is another term for registered is unaccredited.
How many are there?
There are, I have to do this in my head.
There are
20, 19?
It's 35 with the CALs, and they're registered together.
So there are a total of, the problem is we've sort of decertified a couple recently, but there are a total of 56 law schools, 21 ABA, 15 CALs, so it's roughly 20 registered. Mm-hmm.
So far, what we've heard about current support programs, as Judge Brenda mentioned earlier from the discussion at the law school assembly, a lot of schools say, oh, we have support programs for all of our students. We want all of our students to be successful. But there are some schools that have special programs for first-generation students, and this includes family support for their families in terms of providing information about how their family, what the families can expect of first-gen law students and what their experience will be. And there are now, there is at least one school that has a veterans support program. So in terms of supports for diverse students, these are the activities that many of the schools cite. Some have special orientation programs or summer programs in advance of law school before the first year. Many have academic support. This can include both support as the law student is coming into first year and throughout the first year, study groups, essay prep, that sort of thing. What's unique with the academic support is that a lot of the formal programs have these supports as the students are going through the first semester, and there are other programs that provide support after the first semester and where the student hasn't performed as well as they had expected. Other activities include faculty or alumni mentoring, student affinity groups, and special events like a diversity week or a speaker series on implicit bias or microaggressions, for example. Other features of supports for diverse students include diverse faculty, committees of students, faculty, and alumni focusing on diversity and inclusion issues, scholarships for diverse students, low tuition rates, and LRAP programs. One interesting note that came up in the San Francisco conversation about scholarships was that it does help tremendously in recruiting diverse students, but if there's not corresponding support while the diverse student is in law school, then they may lose that scholarship after their first semester or first year because of academic disqualification. So we asked the law schools what data that they are collecting to evaluate whether these support programs are successful. And much of the data is anecdotal and not really focused on bar passage. And focus more on bar passage and not necessarily retention. A lot of the schools pointed me to their 509 reports when I asked for data. A 509 report is the information that all ABA accredited schools must submit to the ABA. Which includes retention rates, matriculation, graduation rates, and bar passage.
So, I'm sorry, you just said that they maintain retention rate.
Oh, I'm sorry, they do not.
Okay.
Yeah. I'm sorry. They maintain retention rates for the entire student body, not for diverse students specifically. So the data from most of these programs are usually, focus groups or surveys or, informal feedback. Some of the schools are working with their institutional research departments to do some evaluation, but so far there hasn't been any available. As I mentioned, we had UC Hastings and Loyola Law School present at the Law School Assembly. And as Judge Holly mentioned, the UC Hastings presentation and program was very impressive. They have over 3,000 alums. Their program is holistic. It has academic support, bar passage support, community support. Likewise, Loyola's program is a 3-week program prior to the start of law school, and also includes academic support and community support, connection to first-gen faculty. And I believe they reported that the students participating in their first-gen programming have higher bar passage rates and retention rates, and increased GPA. So we also looked at the 509 reports to gather some data to see whether the programs at Hastings and Loyola increased retention. And so you'll see here that the percent change from 2014 to 2014 first-year matriculants to 2017 law school graduates. Loyola is in the light blue, Hastings is in dark blue, and the California ABA schools are in green. So you can see that having the programs didn't necessarily correlate with retention and graduation. We are looking at a small data set, so we may need to look further. And you'll see that there is an increase of 23% for Latinx students at Hastings, and that is due to at Loyola, and that is due to Loyola reporting 9 transfer students during the second year. And so our data analysis isn't perfect here. We were just trying to see if there were any trends that we could pull out.
I wonder if, what happens if somebody transfers to another school? Is that just counted as somebody who drops out, or what?
Under the ABA data, there is a separate category for transfers, and so it doesn't count as in terms of attrition.
So I'm a little bit confused.
Sure.
Are we adding in also for Hastings transfers? How did it work? Or was Loyola the only school that happened to report on transfers and it skewed their data?
Their report had the transfers, and that's why the data skewed. Hastings, I think it wasn't included. Either they didn't have it in their report, so I'm assuming that there wasn't.
Pull the transfer out of Loyola so that you can compare apples and
Sure.
apples here, right?
Sure, I think the issue is that we aren't positive that the 9 transfer students necessarily were. I don't know how to explain
They
this.
have to be, because your goal
Right.
here is 0, right? That nobody drops out. The only way to have that graph bump up is to include transfer students. And if you're not including transfers for Hastings.
We did include, I believe, transfers for Hastings. We were trying to include the same data.
It's just that the greater number of
Yes.
transfer students from Loyola is what put it above.
Yes, that's right.
So there may have been transfer students counted for Hastings as well, but just still kept it below.
But if you're wanting to compare those who come in 2014 and go out in 2017, you should not have any transfer students in this data set at all, because what you're seeing here is if you also counted in transfers in these other groups into Loyola and Hastings, they were artificially depressing the downward. In other words, if you pull the transfer students out, those downward numbers might drop even lower.
Well, I think the question is just, we don't know what that data is, and whether we keep out all transfer students one way or the other. And then, but then we also have to keep in mind that those people can't be counted as a negative if they transfer. If somebody transfers from Loyola to Hastings, say, you can't include that. That's going to get all messed up, actually.
Right, and somebody who transfers is not somebody who doesn't graduate. You've got to handle that a little bit.
Yeah.
It's just something to be considered.
Right,
We
absolutely.
need to take to make sure we're dealing with the same stuff.
So let me just add a little bit more context to this slide. So what you see in the green is the original presentation of data to the Board of Trustees on what the attrition data looks like for California ABA schools based on their 509s. ABA schools' data isn't perfect. And so they give us the years, and so we're tracking it backwards about who started and who's graduating. So what we wanted to show, basically to say, these are 2 self-identified positive programs. LEOP has been around for 50 years. Loyola has been around for about 12 years. What does the data show about their program? We understand this is just the first snapshot. This is not capturing everything, but understanding based on just the 2014 to 2017 data, what does it show? And it's not showing a direct correlation for a specific ideal retention to graduation, understanding that there may be gaps in the data itself. Maybe we have to look at a broader section, so 2010 to 2020, right? So that we have multiple years. Maybe they're not graduating in 3 years, maybe it's 4 years. But the only reason we wanted to show this data is saying that, like Judge Fuji's mentioned, LEOP's program has all the key aspects of what we would want
what one would think is best practices for supporting students of diverse backgrounds, from family to academic to career counseling to training and all these other aspects. And so trying to identify what aspects would be good, and maybe we're also now looking at the data from, this is the average ABA data. We're now going to go back to the California ABA data to see, does other schools actually have better retention rates? And maybe they're not doing a special program because it's infused through the whole school, right? So we want to kind of see this in different ways, but the initial presentation was, the call was, let's identify successful programs, and then the charge is to see how we can help expand or identify how we would support more retention. Maybe programs isn't the answer.
Because it really makes it look, from those stats, that with the exception of the transfer issue, that they do worse than the schools that don't have them. So,
One of the reasons I'm bringing this up is data like this has been tracked for, let's say, K through 12. And what they were finding is, and so that was the dropout rate, right? And the school districts were ending up with very high dropout rates. It turned out that if a student moved out of the district, they were counted as dropping out. So this data was completely unreliable. So I think that that's something where you'll want to kind of finesse that a little bit better so that you can get an accurate picture.
And that's what we're doing with the California registered and accredited schools, because this year, for the first time, we're saying we want to collect this data in terms of progression, and we're not modeling it. We're trying to have more data because it wasn't necessarily collected now, but we're not modeling it exactly like the ABA data because we know that there are some gaps. And like you say, is it because they're actually leaving because they're academically disqualified? Is it because they have other financial reasons? Is it because they're transferring? So that we have a better sense of what that path looks like. But what we have now is the ABA data for the ABA schools. So this is what we wanted to present.
but so the ABA data, so we have data for each of the ABA schools, is that correct on this?
On what they self-report on their 509s, correct.
Okay, and it's set up by ethnic group, correct?
It is.
It looks like it from the fact that they've got those.
Yes.
Yeah, that green stuff. And there's nothing that keeps us from getting information from ABA schools, right? I mean, if we ask, we aren't prohibited from asking information or sending out surveys or whatever, or information from ABA schools, and I would bet that they would respond because we do the state bar.
Yeah, we can certainly send out surveys. We have their sort of annual reporting requirements are to the ABA, and so we control for the CALs and the registrants, so we can change some of their reporting requirements. But can we survey the ABA schools? Absolutely.
Yeah, because it seems like we should be. Because I know I keep going back to the idea that the ABA schools is where people think about going, primarily, and that's where overall in the state most people go to ABA schools. And I know that we're talking just with people who are the ABA schools in California, but there aren't that many of them. And if we can get information about this and ask them to collect the data, and maybe we'll get better data from them. I did have to say that I thought, talking to the people from the California non-accredited schools, and this was my experience since I was president of State Bar, which was that I didn't get that high of a sense of cooperation, or that they were very interested, frankly. On the other hand, the ABA schools didn't show up at the law school. Very few of them. I mean, there were besides Hastings and Loyola, like UCLA wasn't there, USC wasn't there. I mean, the local ABA schools were not at the law school assembly. And I thought, considering in Los Angeles, that's where the majority of people come from. People who end up practicing in Los Angeles are UCLA and USC. And I was sort of surprised that there, there wasn't any participation from them.
So I don't recall, there wasn't UCLA, but Southwestern, Pepperdine, Whittier, and we had.
Is Whittier's? Yeah, I thought they went out of business. I thought that was odd. Yeah.
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 So there were
But
about
like,
six
like I said,
ABA.
but USC has 300 students. It has, it's one of the largest. It's having an event in Los Angeles without UCLA and USC. I thought, there really should have been a lot of effort to get them there.
So if I can explain that in the past, so we've recently retooled the way we do this event. So the Law School Assembly is a once-a-year meeting where we invite representatives from all of the law schools to attend. It's not required that they attend. We very much hope that they will attend. But in the past, the agenda for these meetings has been of greater interest to the CALs and the registered schools because they are we accredit them, we can direct that they do certain things. And so we made great efforts this year and got a lot of positive feedback on the way we changed the agenda. And we sent out information ahead of time to all of the law schools to let them know this is going to be a different event than it's been in the past. This is what we're going to do. We did a save the date with sort of highlights. But it may be that there were those who were really sort of thinking about the events from years past, and we will continue to strive to get them at the Assembly because we're going to continue to do it with these broader discussion topics that are of interest to all of the law schools as we had at this one.
Yeah, as I said, I mean, I look at this and I think Stanford is not going to be real excited about the people with criminal records part of the I don't know. Maybe it's something where there should be separate events because Stanford wasn't there, Berkeley wasn't there. Yeah.
I'm just curious, was it a situation where those schools declined attending this year or?
Didn't respond?
Didn't respond?
I honestly don't know.
I have a question about this chart. I just want to be sure I understand it. I'll just take this one. So for example, programs to support diverse students, Loyola and Hastings. So the ABA.
Schools generally did better.
Yeah, isn't that awful? I don't understand.
That's what I said.
Yeah, so I think one of the factors.
Is that correct? Do I understand
Yes.
that
Correct.
You are reading that correctly.
It's as if having these programs
Makes it
made them
worse.
Had worse outcomes.
Yes, had worse outcomes.
That's very
So, but I think the other two things that we should put in our context, Loyola and Hastings have one of the largest law school populations in terms of classes.
But it should, well.
And so
their influence totally, that shouldn't make any difference.
I mean,
Still percentage, 31% of a large population is huge.
I mean, if I were an Asian student, I sure as heck wouldn't go to either one of those schools. I'm just really dumping my chances, aren't I? No, I'm not trying to be funny. I mean, it's serious.
I mean, I think it's.
Unless the data
it really,
unless I don't understand how you collected the data.
I think what's really necessary is a huge dig down into why it is people leave.
Yeah.
Why are people leaving? I don't understand. Is it financial? Is it that they just hate the criterion? Is it that their parents made them go to law school and they wanted to go to med school? But I don't know.
Some law schools are elsewhere.
yes,
Right,
and so
is it voluntary or involuntary?
yeah, in San Francisco.
One of the law schools where basically the dean said that, if it appears they're not going to pass the bar, then we are going to.
Well, that's a standard
back to
California and unaccredited.
We're going to say back
That
to
was
them
their,
after.
that was always their thing.
after the first
They would
year.
bring all the people in, and if you didn't pass a baby bar, you're out. Or they thought you were going to fail the bar. They didn't want their stats to be even worse than they are.
Well, actually, this was from the ABA school where they commented, and several other law schools mentioned this, that they're scholarshiping students the first year in order to recruit them to come. And then based on their first year's GPA, if they don't make the curve, they are then DQing them from their scholarship, and so they're unable to afford it. And the schools have mentioned that they're doing that in order to keep their ABA accreditation. So because they need to pass the bar within 2 years in order to retain their ABA requirements.
But it seems sort of a backwards type of thing, that you think, gee, maybe we should provide more academic support to these people so that they pass the bar, as opposed to saying, oh, let's get rid of them because we don't think they're going to pass the bar. Or, gee, you got people with scholarship, you've invested in these people for a year with this money, and instead of trying to get them to pass in their first year or get to that requisite GPA, it makes it sound like it's a bait and switch. You go, oh yeah, we're not going to give you the support to do this. We're going to give you the first year, and then after that, we're going to charge you for that. Oh, you can't afford it, you're out. Go ahead. No.
I actually have a question. So is there another way that we could actually utilize the data from transfer students? Because I would imagine if I wasn't getting the school experience that I wanted, that would be a factor in me transferring. So I don't know if the 509 report provides some sort of context for why the student transferred from one school to another.
Okay.
That's a really good point. The 509 data is just data. There's no narrative or there's no way for us to capture that information. But I think looking at why students are leaving either to transfer or to leave law school completely is something that we're trying to do.
And so some of this presentation is this is the kind of discussion and a direction that we'd like in the work group for law school retention, because we want to see, like, if it's not a program, what is it that the state bar should identify in order to, address this issue. Understanding that this is our first take at the data, we're still collecting more data, but as Catalina mentioned, it is disturbing based on this initial result. And so, did you have other?
No, I think that's actually a good segue for now Helen to talk about our work groups.
So a lot of the initial work group information, I passed that out as the first document this morning about what are the strategic goals and objectives that we really want COAF to help support, identify, and to dig into the information. There are certain items that we need to report back to the Board of Trustees to help inform what future objectives would be. And so, for example, on Goal 4, it's identifying means of supporting existing law school programs to improve retention by the end of the year. And the work plan includes identifying and reviewing promising programs, recommending effective programs for broad implementation, and participating in the law school assembly. I think, this is something that we can go back to the board saying maybe it's not a program, maybe it's a pivot in understanding what really is making a difference in retention programs in law schools. And so that'll be a work group. And let me take a step back. The reason why we're considering have staff-led work groups, because we want to be able to continue to meet besides the quarterly meetings, and to have the nimble ability to get your thoughts and ideas either through conference calls or webinars or informal meetings without necessarily having a badly keened agenda, so that we can be more nimble. The next one is related to the data on My State Board profile, analyzing available data to identify particular obstacles to diverse attorneys' entry into retention and advancement in the legal profession. And as we discussed this morning, it's making recommendations for actions for the State Bar, recommending refinements to the survey questions, and identifying diversity inclusion programs at law firms and government agencies to help develop and disseminate best practices. The other work group would be to look at modifying the elimination of bias curriculum contained in the minimum MCLE requirements, to consider creation of subtopics and expanding the number of required hours. And so this would be reviewing what our continuing requirements are and the idea of creating additional subtopics. In our email materials, we sent you a link for the new elimination of bias, the new attorney training that the State Bar does through videos. And it's 10 hours, and there is portions that are related to elimination of bias that I had sent the link to. And whether or not COAF should recommend doing a similar mandatory training for all attorneys, and identifying subtopics that could be mandated to advance the goals of D&I, like hiring, promotion, or cultural competency. As a side note, interestingly enough, some of the law school programs identified a lot of the training was not just about what programs that they're providing, but training their faculty and their staff and their peers on more cultural competency, understanding some of the unique barriers that students from diverse backgrounds face while in law school. And the last one that I would like to put together with the data analysis is
Debbie Manning.
developing an annual report card for the state of the profession for 2020. And as we discussed, it'd be like, what should be on there? What would that look like? Do we grade? What would be ways that the data could be used in order to move the field and change practices?
Yeah.
A quick comment before we break up. I've been looking at the data, the stuff that you presented us in the working groups, and I know that the board has discussed this issue, but I thought in our March meeting we talked about one of the pipelines. It doesn't begin or end in law school, it starts earlier. It seems to me that a lot of what we're seeing in the raw data goes back to education and early education. And I think it might be remiss if we kind of just go over that step and just go straight into the law school. Throw that out.
I do think that the retention problems that we're seeing, a lot of it has to do with preparation. And preparation doesn't start in law school. It doesn't start in a 3-week class before law school. It starts before college. It starts high school. It starts before then. And I'm not sure who would do that besides us, frankly. It's not a CLA thing. Those are lawyers. It's something that if the State Bar wants to provide leadership on the issue of how to, it's a hollow promise to get people into law school, or to say we're going to, even if we start at law school and say, gee, what happens then? We want to have these programs. And a lot of these are morale type programs, and they're great. You have the programs that relate to academics, and that's great too. But you can't, if they're, how difficult we all know the first year law school is without having the grounding that some people do not have. And how do we ensure that, or at least do our very best to increase people's preparation when they do get to law school? So I agree with you, Mark. I think that that's something that should be part of the program. I don't know, what relationship that is with whether that's something that we need to go back again to the Board of Trustees on to talk to them about. But it does seem like it's really not effective for us to say, let's start in law school and work from there.
And I'm going to jump in on that and say that it's worse than just a hollow promise. I think it's dangerous because, and I'm speaking as somebody who was a high school teacher and is a college teacher, and I echo Judge Holly's concern that it's not, the preparation goes way before, and the pipeline model that we've been operating on for over a decade has recognized that, and I think that, has correctly recognized that. And the danger is this, that if you focus on retention in law school and you only look at that narrow area and you set as your goal increasing the retention, which is a very laudable goal, but how are you going to get there? Are you going to get there honestly, or are you going to get there less than honestly? Because if that's your goal and we don't look before and we don't pay attention to people coming in without preparation, you have the danger of reaching that goal in a less than honest way, of simply passing people along so that the numbers look good. And then where are they gonna get caught? Are they gonna get caught because they don't pass the bar exam? And then do we start focusing there and, and, and pushing in a way that's less than honest? And then we get lawyers out who are not prepared, and then our judges start to see those lawyers in their courtroom, and the damage to the clients, the damage to the public, right? That the bar is rightfully focused on a mission of protecting the public. But if you're putting out people that are not prepared and don't have the skills, that's the ultimate damage. So yeah, I mean, I think the only way to get that retention number better in an honest way is to push our focus earlier, not just at the law school level. People have to be prepared coming in, and it doesn't happen in a 3-week program before they're officially a 1L.
I guess the question is, if I'm seeing on the council concern about that. Is number one, is that something that within the scope of what the BOT has said we're supposed to be doing that we can do? And if not, should we have a working group that's going to be working on a proposal to the BOT that says we need to expand what our mission is and what we are tasked to do to include this for this reason? Because I think it's become more clear. You know, before we had sort of we had it was more amorphous in terms of, you know, we want to have people, and we were, you know, preschool, you know. I understand that what we had been talking about has been amorphous. I think we're seeing more at this point on a clarified basis what it is why it is that on a public protection basis, the state bar really should be acting on this prior to law school. And maybe that's something that we can have a couple of people working on, just in terms of something, what could be presented to the BOT? Is it appropriate for us to present this to the BOT? I think it comes within certainly the mission of the state bar. And to present to them to say, you know, we should, you know, we propose that this should be added to our goals and objectives to look beyond and before law school. So that's my thought.
And I would just quickly add, it doesn't necessarily mean staff time, or it was COAF members working with other partners and making recommendations. That's something that we can still do.
So I'm happy to address that, Judge Holly. So within for the current work plan, when the board set the objectives, the board identified the law school part of the pipeline as the place that it thought that the effort should be focused this year. So I would say within the existing framework, working on pre-law school pipeline efforts is beyond the scope of what the board had identified as what it thought should be the focus and priority areas. Is it appropriate for a couple of members of COAF to come together and develop a recommendation for the board to consider to expand that? Of course it is. That certainly would be something that you know the committee would be totally fine if the committee wanted to do that and make a presentation to the board to ask them to reconsider that. That's certainly that's certainly within the scope of what the committee is empowered to do.
I would suggest that Mark and Donna be a sort of a subcommittee to put together a proposal for submission to the BOT to expand our goals and objectives, to include that, and to set out all these rationales. Because I think before, and I understand, the BOT is saying, hey, we're law schools and above. And like I said, I think that we might have pushed it a little far in terms of saying, oh, we want preschool, we want prenatal education, you know, that type of stuff. But if we could...
Well, we recognize that, I didn't mean to interrupt, that's okay.
Yeah, no,
I'm sorry. But we recognize that you can't start in law school. It is too late.
Seeing those statistics, it's really quite scary.
It's
But
I don't want to give up on those 22%, that 12%. Like, I don't accept that it's too late.
No, they're
No,
not
no, no, no,
mutually.
I'm not saying
They're not
we're
mutually
saying,
exclusive.
No, we're not
but-
saying don't do that. What
Yeah,
we're saying is that
yeah.
we work on that.
Yeah.
And I think clearly something is not working there.
Yeah.
And even with the Hastings program, as I said, it seems to be making it worse.
Yeah, I just,
maybe
and I gotta
if
tell
we
you,
just got rid of the
yeah,
Hastings program,
yeah.
it'd send the numbers skyrocketing.
Yeah.
But
just-
to recognize that part of what we need to do for the public protection is to get people better prepared for law school for a longer period of time than just that 3 weeks. And I do think that the thing is that, you know, whether it's teaching people how to you know, read more critically or write better, or, you know, those things. There's so many things that and just to increase their confidence in how they can do in law school. If we looked at the college years, I think we could make a huge headway just dealing with the colleges, and we could possibly do that in connection with, for example, the academies plus the 2+2+3. Have that part, because that's part of our mission, right? Is to deal with them and to interface with that group. If we could work together with that, and at least have that be the start of working in that, because I look at those numbers, and it's heartbreaking, because these are people who really thought they were going to become lawyers, and who, you know, in those cases got into ABA schools, which is tough. And then they dropped out at huge rates, and it's, you know, and also it costs a lot of money for them. It costs a lot of money from the school. It takes a lot of resources from the school. There's a lot of things that really, if we could work together with the law schools, especially those that are involved with the 4+2+2, but whatever number that is, 3 program, because they have an interest in keeping people in. They have an interest in having people go through. That'd be great.
Can I?
I have a question. What happened to the 2+2+3 program?
Still there. It's with California lawyers.
California Law.
Cal Law, Inc.
And that was part of the, again, you've all heard this, is part of the analysis of the Board of Trustees, that there are folks like California Law involved in pipeline, right? So the board wasn't saying this part of the pipeline's not important. What they were saying is there are people like California Law, for example, who are involved in earlier parts of the pipeline, and where is the bar uniquely situated to be useful, to be valuable. And that was the law school focus. Just 2 more very quick points. I would not, I don't think we're prepared, we've done enough of a look at the data to attribute a causal relationship.
No, I'm not saying,
So
I'm not going to say we should get rid of Hastings entirely, because clearly they're dragging us down.
And then procedurally, I think it would be better if it didn't, if we asked for volunteers as opposed to the chair sort of naming volunteers.
Okay. Do I hear volunteers? We have 2 volunteers.
You have 2
We're
volunteers,
good.
that's right.
Yeah.
And can I say something as well? You know, on the one hand, our charge is still pretty broad, because we can assist and advise the board in defining and advancing the State Bar's diversity and inclusion strategies and goals. And these kinds of things, what we're basically stressing, you've got to go back to before law school if you really want to advance your diversity and inclusion strategies and goals. And to identify barriers to entry into and retention and advancement in the legal profession, and propose solutions to address barriers. Well, one of these barriers is, you know, the early education aspect of it and the deficiencies there. So, I am hoping that the board will receive and fairly consider recommendations that we put forth, that, you know, that will help them, and then they not see it as any kind of challenge to perhaps their sense of, well, we
Right.
just want to focus
Right.
on law school. I'm hoping that they're not going to come back and say, well, that's not law school related, so that may well be outside of your charge.
I would say that's what we're looking for from this little working group is
And then
is a rationale for why it is that the state bar and not just say CLA work together. Whether again it's like for the judicial toolbox that it's the Judicial Council and us working together. And they've told us they want us to be doing, a lot of work on this, especially when it comes to implementation. And that's part of, it's part and parcel of what it is that we should be doing. So again, we are partnering with other organizations. We're not saying this is, let's take it back from CLA, let's only do this ourselves. What we're talking about is coming up with a plan for, and maybe again, reaching out to CLA, reaching out to Cal Law, absolutely, and saying, what can we do to help you? What can we do? And then and put that together as a proposal.
And give us some more members of COAF so we can do that.
Mm-hmm. Yeah, there is that.
We would have emissaries, we would have liaisons, we would have representation on in these organizations that are doing things, so that we can make sure that what we're getting from those organizations and their focus is going to coincide with the state bar's goal of increasing diversity in the profession. So those are the kinds of things that we could be doing and should be doing as COAF. We ought to have somebody there at the table at all of these organizations, and then be able to come back to COAF and say to COAF to pass on to the Board of Trustees that these are some things that we need to be looking at. So I just, I hope that when we come in with the recommendations that they be taken as a serious attempt to help the state bar achieve its goals.
I think the problem with saying, let's leave it to CLA. CLA, again, is not the regulatory agency. CLA is like, they go in, they can look at and I mean, they can go, oh, look, retention rates went down. That's too bad. I think you have to put together what the state bar does in terms of whether it's gathering information and processing that information, which I think we're doing a great job at developing, to put that together with a programmatic aspect. Otherwise, we're just saying, look, the figures are bad. It's part of the state bar's mission to increase diversity in the profession and not just sit there and look at it. So that's that. But I think that again, I think we've got two great people to work on a proposal for the state bar to how we can work together with these other groups and to put together some programs to make sure that the people who are coming into law school are better prepared.
And we see it more as prevention. It's kind of like a health issue or something. If you can prevent that health crisis, then what do we do to prevent it? It's a crisis when you get into the law school and you can't get out. You can't graduate. Is there anything you could do before the person gets into law school to ensure that they don't get afflicted with that kind of condition? And that's what we can be telling the Board of Trustees, and that's what we ought to be looking at. Because by the time you get diagnosed with that condition, it really is too late to do a lot about it.
So my
let's
proposal
prevent
to
it.
the board to add that to the work plan would be that approach, because I do want to caution, right? The charge is intentionally broad. The board approved sort of the work plan for the year, and so I think Judge Holly, as you appropriately said, what Mark and Donna as our volunteers on this would be doing would be putting together the rationale for why you believe that the work plan should be expanded to include this other work, in addition to the items that are already on there.
Right. Because I think it does actually come under the law school retention, but it broadens the scope. of that. It's not just saying, once you walk in the doors of the law school, how do we
Mhm.
make sure that we keep people in there? So, but, so.
Merging of early education, you have legal
Right.
education, and one kind of review of the whole educational process from, well, high school, college, to law school, which is the
Right.
snowflake approach.
It's just, yeah.
So if I just could follow up on Mark's question, I did meet with Pat and the relationship with Cal Law, and I said, propose an MOU. What would that relationship look like? What is it that you'd like? And so we are talking. It's not that it's over. The idea is, how can we be supportive of each other? But I also want to put into context that much of what, from my understanding, as I've been getting more familiar with COAF's history, a lot of the policies and recommendations were not necessarily as embraced by the Board of Trustees, the Board of Governors in the past. And now the COAF has the opportunity to actually make recommendations on policies like the MCLEs, like these other areas of how do we use data in order to change practices. And so I don't want to lose focus on the fact that, yes, it's just important. I am completely personally very passionate about early education and the education system, but understanding what opportunity we have with the current Board of Trustees in terms of what kind of change we can make with policies as a regulatory agency is also another perspective to look at. And so that is kind of why the recommendations to the board in terms of what they could do, like with MCLEs, in order, for example, to mandate like faculty members who are licensed in California to take these implicit bias and what that would look like and who would be performing them and what that would be. That is something that COAF can make a recommendation on.
Yeah, okay, and I understand the importance of that, and that's certainly some part of it. That I think of as a very tiny part. I really do. But that's, again, that I think looking at this and keeping in mind that, like, when I was president of the State Bar and COAF was in existence at that time, that it wasn't that COAF didn't have a policy seat at the table. It was that COAF could make its decisions on what it did, and COAF created programs without having to go to the Board of Governors at the time and ask for permission to do that. We had our role, the goal, because I was
You're
on
in charge.
before. Yeah, I was on and Brenda was chair, and I was president of the State Bar. And it was never a question of, okay, well, you come to us and you tell us why it is that you think you should be able to do that. It was like, if this was within the general mission of what it is that you were supposed to be doing, that's what we did. And so now we understand that we're in a different universe right now. Yes, yeah, whatever. And so that's why I'm saying let's put together the structure and talk about where have Mark and Donna come back with proposals and really concrete ideas on, number one, why it is that this is imperative and part of the State Bar as opposed to, say, the CLA mission. Why it is, how we can partner with them. So you contact them, talk about that, and talk to Leslie Cunningham at the Law Academies, and come up with a proposal, because what we're just trying to do, we're really trying to do what it is the BOT wants us to do with regard to retention. We just look at this and we say, we don't want to do this with one hand tied behind our back, or basically to say, well, both hands tied behind our back. You just take those students as they come in, and then you try to fix them. So I think that's one thing we're doing. Should we have a separate group on the other law school retention? Oh, I'm sorry. I'm sorry.
In my head, I think I'm a pretty procedural person. So is it an instance where the two of you are working on something that you'd bring back to this space first, or go directly to the Board of Trustees?
No, they'd have to come back to at our next meeting.
Okay. And then is there a goal towards a specific Board of Trustees meeting that might be upcoming? That way we know that.
When are the future BOT meetings?
The one after September would be November, if I'm correctly, because you guys are going to we're gonna reconvene in September, so the next one after that would be in,
Okay, that makes sense.
November.
Thank you.
And
Because really what we're.
September what? Oh, that's
Oh, yeah,
what's our
sorry.
next September
So
meeting?
the next co-op meeting is September 13th, and then the Board of Trustees meets on September 19th and 20th.
September 19th or November 19th?
September, but you wouldn't be able to
Oh,
get on
right,
the agenda
Right,
10 days
okay,
in
sure.
advance, so the next one would be in.
November 14th and
November
15th.
14th, 15th. Okay. Because really, I mean, what we're really looking for, we're not looking for, you know, like we want instantaneous, everything is going to change type of thing. But we're really looking for making this change so that we can make plans so that starting basically in the next year, doing, expanding our charge there. Okay. Yeah, being more effective. Okay.
And it won't really be expanding the charge, it'll be
Right.
revising the work plan.
Right, revising the work plan.
Which they
Exactly.
do every year, the board might do every year anyway.
Right, so, okay, I think that works well with that. So what we had listed here is, work groups on law school retention. Okay, yeah, why don't you, and to talk about, because, yeah, the thing that really kind of bothers me is that the Hastings plan sounded so wonderful.
But I gotta tell you, I really, I'm just
like-
gonna say,
It was like
I think there's something
unicorns and-
wrong with the
right.
way, I think there's something wrong with the way we've analyzed that data. It just
There's
can't be
something
that
weird,
way.
yeah.
There's a glitch, there's
Yeah,
something.
maybe
It
they
just
all
can't-
transferred to Harvard.
It just can't be, exactly. You know, maybe
some
that's
crap
what they
school
did,
like
but
that.
it just can't be that they're in worse
maybe we should
shape from
find out
having
more
all
So
of
the
that
work group
support.
will dig into that. We'll
Yeah,
definitely
I
dig
think
into
that's
that.
what we need to do, and I certainly would not want
Yeah.
us to leave her even thinking that Hastings students are worse off from having had all that support.
Maybe they're spending all of their time in those events.
No,
And they're
I don't
not
think so.
studying. I
I
don't
don't
know.
think so.
Yeah.
I think and I know too many people who've gotten through the LEOP program and stuff, you know,
I know.
successfully.
I
Yeah.
know.
Yeah. I mean, you're just, you know, too many people who've gotten through it. So I think we need to take a look. And then I'm not quite sure what the California data too. I mean, what it's including. So I'd
Yeah.
want to.
I think
drill
even if
down
we
more.
just look at the ABA data,
Yeah.
that is enough to support the idea that we need to dig a little deeper down in terms of preparing students for law school. So
Yeah.
it's part and parcel of the whole retention issue, but it just goes a little deeper. So yes,
Law school retention. So you have Mark and
yeah, we have Mark
Mark's on
and
the law-
Catalina on that. Are doing this other stuff, but Mark just volunteered.
He volunteered
to
for
do
the law
also-
school retention.
Well, see, the problem, okay, and let me check on this, okay? In terms of Bagley Keene, that's why I'm saying I was talking two.
Oh, I thought she
Because
said.
otherwise
I
you
thought she
can't
said
have
work groups of 3.
conference calls. So that's why. So
Oh, okay. All right. It said the work groups, we'd have 3 work groups of 3 people each is what's on the agenda, is what I'm looking at.
I'm sorry, for our discussions today, since there's, I believe, 9 co-op members in person.
So we have 3 of 3, but then but then we'll need just 2 permanent members to be appointed to each.
2 members to
or just
volunteer.
two,
yeah.
2 members to volunteer.
But I mean, those would be 2 official members. But otherwise, just comply with Bagley Keene.
Bagley Keene's.
Okay. All right. So of the 3 who have volunteered.
No, that doesn't matter. It doesn't matter. You can't have meetings or phone calls or anything.
Volunteer to do it by themselves or whatever, and then come in.
No, that's no. We're judges. We can't do that.
Yeah. we can't do that.
Jeez. What
For
is
today,
wrong
for
with you?
today's
You're a
purposes,
lawyer.
we'll have work
Honestly.
groups of 3, and perhaps at the end of the presentations, we will then
Designate 2 people as the
designated
people who are going to be
2
working
members
further
to
on
be the
that.
work group, 2 volunteers.
Volunteers, yes.
Okay.
Yeah. Well, yeah.
Okay.
Yeah.
Why
yeah.
don't we
And
have?
we're not appointing, but they're going to volunteer. But we do have
Yeah,
to.
it doesn't matter.
We
This
have
is
to-
still
We
still
have to
Bagley Keene.
confirm.
Why don't we?
It's
why
like
don't-
signing off on a stipulation. Yeah, the lawyers can stipulate, but then the judge has to Approved. Sign off on that stipulation. So anyway, okay then.
I
So,
just got a
so
stipulation
we'll
that
get
said,
the two
sign
final
this, Your Honor.
volunteers.
And I look,
Yes.
I go, you guys didn't sign it. And they're going, yeah. You didn't sign it. Like, so how is it a stipulation? Well.
So what are our other work groups then? So we got law school retention. We have 3 people for that.
Yeah, so we've got Catalina and Mark and Donna are going to be talking about that and sort of working through how that's going to get done. Modification of elimination of bias MCLE curriculum. Who wants to work on that? Okay, so good. We got Connie. Anybody else? Don't make her, hang out there by herself. Okay, Esther, thank you. Okay. And that whole attorney data review and analysis, that's kind of what all the complaining we were doing. Everybody who complained about, yes, Barry complained about it. Okay. Yes, so did I.
No, I volunteer.
Okay, good, okay.
Very volunteering.
So
the chairs and everybody.
Yeah, we'll just wander around. So Yinka, were you on a?
Where's Esther? Did Esther?
No, Esther signed up for modification of elimination of bias.
Modification. Okay, that's Donna and Esther. Okay.
No, it was Connie and Esther.
I'm sorry, Connie.
Yeah.
Donna. Connie and Esther, not
Donnie.
Yeah, Connie
Yes.
and Esther.
Yes.
And then there's Barry and who else for the attorney data review?
I'm thinking the data portion.
Oh, okay, good, perfect. You can work with Barry on that. Okay, so why don't we break off and meet back here about 2:45? And, basically the idea is to talk about what it is that you want to do, what is going to be done. It's not so much solving all the problems, but saying what the problem is, what we're going to do. And again, the idea being that we're going to report back at the next meeting in September, okay? Yeah.
2 of the groups can meet in here, and then we have next door as well.
Okay. Or you can go out and there's that table out there. A lot of people meet out there. Okay. Either way. All right. See you back here at 2:45.
So for staffing, in terms of contact, Donna will be doing the MCLEs, Elizabeth will be doing multiple retention, Carolina and I will be doing the data and the report card.
Okay.
Sounds like the law school retention all on this side. We'll take over this side.
Okay. There we go. All right. All right. Here we are back after meeting with our work groups, and let's see. All right. All right. Calm down here. All right. Okay, so the law school retention and before planning group. Mark, you want to give a report?
Yeah, I sort of volunteered for that one.
Mm-hmm.
We met. We had a very good discussion. I think the focus.
Mark, hold it. He's complaining already.
Move it around, yeah.
There we go.
What happened to just getting one of those microphones and
The
pass it
focus on law school retention, we think, should be on financial, social, and academics. I know broad topics, but for the state bar, especially Elizabeth, is to focus on surveys, kind of fine tuning the questions that are to be asked, and also to ask financial aid departments, student affinity groups, and also other programs to figure out what's going on to kind of refine the data. We also discussed programs on retention, which goes back to before law school, which I won't get into today. We'll say that for later. And then also writing apparently is an issue for law school retentions, and some ideas that were floated around, like an English placement exam when you get to law school to figure out where you need to be diverted to make sure that you can write, so that when you see our briefs, you won't gasp and horror that this person cannot write. That was it in a nutshell. We have a lot of other different ideas that will be worked on in the coming months.
Yeah, I think.
Did Elizabeth, did I miss anything?
I agree. I think writing is a huge thing, not just for exams, but the bar exam and then for practice. So that's it. Yeah.
So we'll work on that aspect.
Excellent.
Going back to the high schools
Right.
At a later date.
Great. All right. Thank you. And modification of elimination of bias, MCLE. Who is going to report on that?
So the heading said modify the elimination of bias curriculum, but the word we got was actually what they wanted to do was modify the rule.
Oh.
Not like our curriculum that we have. So that's what we talked about. Just wanted to start with that so you're not all lost by what I say next. So what we were talking about doing is expanding the rules. Currently, there are 25 hours required of MCLE every 3 years. I already forgot how many were. Thank you. 4 legal ethics, and then there's 1 hour of elimination of bias required. Our suggestion is that we increase that to 2 hours, one of which being focused on implicit bias training or unconscious bias, and that we suggest that the state bar develop a training so that it can roll that out with the new requirement. Now, we wanted to be very clear, we're not adding to the 25 hours, not making it 26. We're just using one of the general hours should be used for implicit bias training. We think that the bar could do a online training, which should be given for free, and that way it would make it a little bit easier for people to take it. We also think that someone or a couple of someones from COAF should be involved in developing the training. And we sort of brainstormed a couple of ideas that I don't know if we need to get into those right now, but we had some sort of fun ideas, like just to make it interesting and impactful, because that's my concern with having an online training, is that people will just start clicking through on their lunch hour and they won't really pay attention. So one suggestion was to have a TED style delivery, maybe send out like a RFP kind of a thing to the attorneys in the state and say, hey, do you want to give a 5, 10, 15-minute talk on elimination of bias? We could divide them up by actual like subtopics, have maybe 4 of those, involved in the training, just to make it a little bit more entertaining and make sure people are actually watching. And so what would be required of that is to draft a new rule, which the staff here could help us with, and then we would have to take that new drafted proposal and make an actual rule proposal along with it, take that to the Board of Trustees, and then there's all the other requirements, having public comment and all that other things that would have to happen. Another suggestion was that apparently the state bar currently, if you are a MCLE provider, sort of in good standing, if you've already done 4 approved trainings and you're a, what was the term again? Thank you. Multiple activity provider, then
MAP, a map.
yes. So apparently after those first 4 that you get approved, the state bar never pays attention to what your MCLE is anymore. They don't review the curriculum. They don't do anything. So we suggested at least thinking about requiring that elimination of bias, or particularly if it's going to be an implicit bias training, that curriculum has to be sent into the bar to be reviewed again, just to, we've all been to quote unquote elimination of bias trainings that don't eliminate much bias. So we thought that might help with that.
Doing that from memory in terms of how many times we look at the curriculum and the agenda, so that might be wrong.
Yeah, okay, so yes, but there's a general rule.
Do it more, you know, spot check after, or maybe
I don't think so.
every 3 years.
Because I was just thinking of Paula, we were going through and saying, okay, we need to do 4 in 2 years, and then afterwards we don't have to worry about it. So, yeah.
Yeah, so, you know, we just want to make sure that we don't roll out a new requirement that has no impact. You know, we want to make sure that it has an impact of some sort. And those were the high points. Anything else that I missed?
So for the September meeting, our committee is going to have a little more information as to what the costs are going to be. Since there is a Robert White, he is part of the California Minority Council program. So we're going to talk to him about some of our ideas, rolling out this additional amount of CDB as part of the requirements. So we'll have a little more information for the council at the September meeting, and hopefully we'll have drafted the rules so that we can actually speak about it.
Attorney review and analysis.
So in our small group, we actually went through the questions that prompted the data that we went through this morning, and so it was really helpful to help refine what those questions are and what they might look like moving forward for future years. And then we also spent a little time about what we might want to highlight.
Her mic isn't being projected. I'm getting emails from our communications people, like, speaker's mic is off.
Okay.
Well, maybe I did turn it off, but the light didn't go off. I was trying to.
Then we spent some time looking at what would the report card look like, talking a little bit about from a private firm what would be interesting to help any type of group move forward as far as diversity, like and advance themselves in making their firms more diverse. And so I didn't take as many notes as far as takeaways and next steps. And so I don't know if anyone wants to, who had captured those, wants to share those out. Oh, I took notes, just not the next steps portion.
Yeah, there we go.
I think what we're looking for is really sort of an outline for what it is that you would be doing in your working groups, and to be able to talk during the interim, and then come back with a plan at the next meeting in September. Okay.
Sounds
So,
good.
so you can go back and check it out later. Okay. Any
Oh,
any further comments?
There was a discussion around looking at specific target populations. So those attorneys that we saw reporting dissatisfaction were high amongst Asian and women, and looking at the intersectionality of women of color. We were interested in digging deeper into LGBTQ, and also thinking about what would make so what is the standard? Like what should it be? And looking at the different representations in the California population and seeing how that plays out in these targeted groups in the private sector and then possibly in other sectors as well.
Okay. Could we also get, and we'd sort of talked about this, about data on other professions, on things like satisfaction?
By the way, dentistry has the lowest job satisfaction.
Oh, of course. You have your hands in other people's mouths all day. Ugh. And everybody hates you. I mean, nobody likes lawyers, but everybody hates dentists. Yeah, it's true. I hate dentists. Implicit, no, it's explicit bias. It's very explicit bias. Okay, anybody have any questions again for for how our marching orders are for preparing for the September 13 meeting? And so if everybody could talk about setting up, conference calls, because it's just two people or at a time. Oh yeah, and we also have volunteers, correct? We have volunteers on the issue of pre-law school. Yeah. Yeah. Yeah.
Well, Kat will be the main person, and then bring one of us depending on the
Not three. No, two. Only two. Okay. I appreciate it. Right, on that issue. Excellent. Okay, great. So that's great. We have our marching orders on what we're going to be doing until the next meeting. I did want to say one more thing. Oh, yes.
Just so we're clear, so the volunteers then for law school retention, we have that.
Yeah, microphone.
Sorry, the volunteers for law school retention, we have those two, and then the two who reported on modification of elimination of bias, those will be the volunteers for that work group.
Yes, yeah, I thought that was, yeah, sorry.
Two would be the volunteers for those. Just confirming.
Okay.
For the record.
For the record. For the record. For the record.
There's no
There
court
is
reporter.
no. Elizabeth's writing down a record. I can tell. She's typing.
And also just a question, is there anyone from co-op who's not here that would potentially be joining one of these groups at a future meeting? Or is this everyone? Everyone came today?
I don't think we want to add everybody, do we?
Yeah, right now, because of the limitations of Bagley-Keene, I think for now we're going to keep with the two.
Okay.
Thank you. One thing, sort of an announcement I wanted to make on that Brenda and I heard from, we're working with CLA in connection with the Diversity Awards. So I think what we need to do is probably maybe I'll send to Elizabeth the email about the announcement requesting nominations for the Diversity Award for Law Firm, the Diversity Award for Organization, and the Diversity Award for Bar Association. Bless you. And so if you have any ideas, if you could spread the word among your own constituencies on people who would be good candidates for those awards. We like to have a lot of applicants so that we make sure that the people that get the award are really, really worthy. Okay? So I will send that to Elizabeth probably tomorrow. Okay. Let's see. Anything else we want to talk about?
Judge Holly, I have a
Yes.
question. how many vacancies will we have on this council, and how will the new people be chosen, and when, will we even know who's taking my seat?
I don't think you get a specific seat, Kathleen. I
This
mean,
is- this
right
is my
there,
seat.
I don't think. Yeah, exactly. Helen, you want to explain that?
Sure. So there will be up to 5 vacancies for in the beginning of the September COAF meeting. So we had 23 applications, and I say up to 5 because the term could be extended for an existing vice chair to become chair. And if that's the case, then there's only 4 positions that are available. And so Elizabeth and I presented the slate to the chair and vice chair for the recommendations. And then the process is that goes to the nominations committee of the Board of Trustees. That will be going in the July board meeting for, so they will review and make their determination, which may include interviews or meetings. It's a new process now. And so this is my first time going through it, as most things are. So based on their recommendations, it'll go to the executive committee. Is that correct, Donna? And so that'll be on the board agenda item in July.
When do they become effective then? When do the?
It starts in September, so the September meeting, does it start in September?
Oh,
So we don't show up in
No,
September?
you do. There'll be one meeting overlap.
So the new people will also be there in September?
No, so the September terms. I guess I just had to touch. Terms typically start would typically start after September 20th. Your meeting is on September 13th. So you would all be here for the last meeting in September, and then the new folks would start for the meeting after that.
So,
The seats that are up would be mine, and this year you do have to apply if you want to be the chair. So I did make application to be chair, and the vice chair. I guess would Esther's seat be up as well? Otherwise, this year she would still be on. Yeah, but Catalina's seat would be up, and who else? And Barry's. And Mark's would otherwise be up.
so were the chair and the vice chair allowed to vote on, or were you? You got to weigh in, so did all 23 names going, or were you allowed to? Because I thought you said there were 23 applications.
But there's only 10.
No, there's four seats.
We did not weigh in on all 23 applications. It was sort of called down.
Yeah, well, they were called down, and then we gave our recommendations based upon the call down list.
You recommended 4?
The final decisions will be made by the Board of Trustees. So COAF as a group, as in the past,
Your lights off.
will not weigh in on who should come onto COAF.
All right.
We will know in July, I guess, who your new chair will be and vice chair.
Okay. All right. Anybody else have any other thing they want to discuss here? Anything else? All right. Yes. Do we have a second? All right. All right. All in favor? All right. So the meeting is adjourned. Thank you very much. We'll see you back in September.